Good morning, Mr. Ngiza.
Good morning, Commissioners.
Good morning, Mr. Ngiza.
Morning, ma'am.
Yesterday, we closed off with a discussion of annexure PN2. Actually, before we go there, Mr. Ngiza, please confirm that you still have both files, the witness statement and the annexure bundle in front of you.
Yes, I do.
Thank you. If we could then pick up with your witness statement. We were on page 11, paragraph 27. Page 11, paragraph 27. Please let me know when you're there.
I'm there.
When we closed off yesterday, we had worked through annexure PN2, which is in your annexure bundle. It contained screenshots of a discussion between you and your superior, Mrs. Kashega.
Yes, sir. Yes, ma'am.
Thank you. I don't need us to work through that again, but we can perhaps just provide a recap of where we closed. In summary, the WhatsApp conversations reflect the discussion you had with Ms. Kashega on the 20th of February 2023. Is that correct?
Yes, it does.
Thank you. Wherein she raised with you a need for security in light of the disciplinary action that you intended to take, at least the suspension that you intended to take with respect to the brigadier. Is that correct?
Yes, it was in respect of the suspension.
Thank you. If you...
May I just ask this? Morning, Mr. Ngiza.
Morning.
I had meant to ask yesterday, and it's because of what happens later, and in particular, the circumstances in which Mr. Mkwana's suspension was uplifted, and then he was told to come back. So it is in that context that I asked the question. Where you say that Ms. Kashega expressed that, and if I don't want this thing, do something about it. You remember that evidence?
Yes.
Did you understand her to be reluctant or not to want to be part of the suspension decision and process? What did you understand of that?
Thank you, Madam Commissioner. Indeed, my understanding was that she was reluctant because of the risk associated with the suspension itself. I didn't understand her to be reluctant in respect of the substance of the issues that pertained to the suspension, but it was the risk issue that she expressed more concern about. She did not express concern about the allegations themselves.
Thank you.
Thank you, Commissioner.
Can I just follow up on that? On page 12 in the bundle, PN2.
Yes, Commissioner?
Are you there? PN2, page 12.
Yes, I am.
You say there we need to strategize around it. Our subordinates have horror stories.
That's not me.
Is it not you? That's her?
That's Kashega, yes.
Okay. And did you know what she was referring to? Because, I mean, at this stage, all you are dealing with is the suspension of a brigadier. Why would there be concern about safety of yourself or Kashega or other people at that stage? Forget about what happens later on.
The concern about safety, if you read the commencement of the WhatsApp engagement, I had expressed a view that this matter is not going to be a simple disciplinary matter, because it involves a character who's outside of the institution, who is in the news, and is in the news for wrong reasons. So she also responded to say that indeed this is a very delicate issue, Now, on page 12, you would see that she had firstly requested, or rather asked whether indeed there was a risk assessment conducted as per the WhatsApp on page 11 at 11:03. So the risk assessment was a key issue to her. But then she expresses another concern at 11:07 on page 12, where she says, but I don't want people penetrating my private space. Nah. I'm too private for Lama VIP who reports issues to some of our subordinates. So what she's talking about here, in the institution, under the Specialized Services Unit of EMPD, we've got the VIP Protection Unit that then would have guards or they call them inspectors. So everybody that is a VIP Protection Unit member is an inspector. Those inspectors are then allocated principals. Now, what Ms. Kashega was raising is to say these people have tendencies of relating the private life of their principals, you know. So she says to me that I'm a private person. I don't want to be guarded by these people because my issues will be known, you know, in the institution. And that is what she's trying to deal with. And hence, her response to my 1109 message that talks about strategies is informed by that concern that she has, you know, with regards to intrusion of her private life. Yeah.
Thank you, Commissioner. Thank you, Commissioner. Mr. Ngiza, let's just make two important points here. If I could ask you to turn to page 9 of that exchange, page 9. You send a message at 11:03, the nub of which is you confirming that despite the security challenges, you are going to send her the pre-suspension letter within the next 15 minutes. Is that right?
Yes.
Thank you. If you then just turn over the page to page 10.
Yes,
at 11:04, Ms. Kashega asks you, have they done EMPD preliminary investigation though? And you respond immediately, yep.
Yeah.
Correct. So you respond in the affirmative to say that EMPD has at that stage where you are on the brink of issuing the pre-suspension letter, a preliminary investigation has been done.
Yes, I responded in that manner, Counsel, because you recall that I had indicated in my testimony yesterday that I had a session with Commissioner Spies and Lieutenant Colonel Erasmus, where indeed they had indicated to me the assessment that they had conducted, what I called some form of a desktop analysis of the registrations and the likes. So when she asked me that, my response was in respect of the discussion that I had with Spies and Erasmus.
Thank you. Could I then ask you to stay in the annexure bundle and just flip over the page to annexure PN3. PN3. The actual document itself will begin on page 13 of your annexure bundle.
Yes, ma'am.
Okay. Just to locate us in your witness statement, you are now at paragraph 28. And the annexure we are looking at now is PN3 that starts on page 13.
Yes.
Thank you.
There.
Could you just confirm for the commission what is the title of that document at the top of the page in bold?
The document is titled Intention to Suspend to Suspension Letter.
So please confirm that that is the letter you were referring to in your WhatsApp communication with Ms. Kashega as
Yes, it
discussed. Thank you. Right. At the top left corner of the page is a date. Do you confirm that that's the 20th of February, 2023?
It is the 20th of February, 2023.
Thank you. If we have regard to the box, the details in the box just under the heading of intention to suspension letter. The suspension letter relates to which employee,
Mr. Julius Mkhwanazi,
who at that time occupied what designation?
Director Specialized Services / Brigadier.
Thank you. Sorry. If we'll just go through some key aspects of this letter, it reads, Sir, the municipality has received allegations of serious misconduct against yourself. The allegations that have been received by the municipality relate to the following issues, and it lists 6 issues under there.
Yes, ma'am.
Mr. The third paragraph then, the paragraph beginning, the employer has reasonable cause to believe.
Yes.
Are you there? Thank you. Could you set out briefly for the Commission what are the reasons that motivated the issue of this intention to suspend letter?
The suspension letter started off, of course, by enumerating the issues in terms of the allegations that existed at the time against Brigadier Mkhwanazi. Then the employer would be, this is the standard that we took from the collective agreement, that if you are going to suspend an employee, you must articulate that your suspension is in relation to these factors as per the collective agreement. So the factors that would inform the suspension would be, 1, that his presence you may jeopardize the investigations that are required to be conducted on the matters raised above or herein. 2, you may interfere with potential witnesses. 3, you may commit further acts of misconduct. Yes.
Thank you. And the paragraph right beneath.
Mr. Nzinza, what informed number 3?
Mr. Chair, that our experience is that indeed when an employee who is facing allegations of misconduct, especially allegations of misconduct of this nature, the nature of these allegations was such that they might be continuous in their very, in the conduct of the employee. The registration of the vehicles, yes, had been done, but the fact that the registration continued, he might do certain things, and indeed did do certain things that I will talk to further on, to misconduct himself further. It might happen. There are issues about dishonesty. And if indeed an employee interferes with documentation, that is a perpetuation of the dishonesty. So that's why we always have this to say, is there a potential for this employee to commit further acts of misconduct, which might be linked to the allegations themselves, or even his presence in the workplace might actually expose the institution to further acts of misconduct.
Thank you.
Thank you, Chairperson. Mr. Nziza, the final paragraph at the foot of that page invites the relevant employee to provide representations on why he or she should not be placed on precautionary suspension. Do you see that?
Yes, ma'am.
Indeed. And it invites them to provide those representations by the 22nd of February.
Yes.
Okay. Can I ask you then to flip over the page?
Yes, ma'am.
Right. Paragraph 5 at the top of the page requires the relevant employee to vacate the premises of the employer with immediate effect. Do you see that?
Yes, ma'am.
Thank you. Could I then ask you to identify the signature the first signature that appears under yours faithfully?
The first signature, Commissioners, is my signature, Olani Nziza, DH Employee Relations.
Followed by the signature beneath, please, belonging to?
The second signature belongs to Linda Glashega, who at that time was the acting HOD HR.
And then please identify the final signature, the third from the top on page 14.
The final signature on the document is an acknowledgement of receipt signature. The person had printed his name, J.D. Mkhwanazi, and had signed and also dated the document.
Please provide the date.
The date is the 21st of February 2023.
Thank you.
Are you leaving the letter? Yes. Okay, maybe then let me ask my question. In the first page at 13, page 13, you've got Roman figure 3 and 4, and the allegation of gross dishonesty and possible corruption by receiving a donation in excess of the limits prescribed by council, and then the second one says allegations of violating council policy by not declaring the donation. Now, the evidence so far that we have had that relates to a donation is about printing material of about 300,000 rand by CAT VIP. Is that what this refers to, or it's a different, in your recollection, I realize it was in February 2023 when you signed this. If you can recall, was this something different to this printing material for cadets in the amount of about 300,000?
The allegation that was brought to our attention was framed in these terms, Madam Commissioner. Remember, at this point, we as the Labour Relations or Employee Relations Unit and HR per se were not seized with the actual investigation report that would have then detailed what exactly the donations were about. But on this day, when we crafted this letter, it was on the basis of the submission from the department to say that was a donation, but the nature and form of the donation was not clarified at that particular point.
And then secondly, in page 14, where you say he's required to vacate the premises, that very last paragraph there, the paragraph doesn't say to him, which we have had happened to Chief Mapie and to Commissioner Spies. It doesn't say to him he must surrender his tools of trade, his firearm, and his computer. Does that mean he was allowed to keep this when the other two were told to hand in even their firearms? What does this mean?
Perhaps, Madam Commissioner, I can start off by indicating that what happened with Chief Mapie and Commissioner Spies was not the standard process, you know. This is a pre-suspension letter. It's not a suspension letter. The person is not suspended, you know. This is a letter that says there is a view that the employer has taken that we should suspend you. However, we must give you an opportunity to present, you know, make representations why you should not be suspended. So at this point, you're not suspended. So there's no basis for me to say hand over things when you're not suspended, you know. And we use this paragraph on page 14. You know, we remove you indeed from the premises so that you go and actually concentrate on crafting your representations, but also to ensure that there is no malfeasance that happens in the process. Because the minute a person receives this, and again, it's experience, you know, we give an employee this, and then you hear from witnesses or from other colleagues to say that, hey, you know what, this person was doing this person was at the office looking for files and all sorts of things. So we prefer that you move away, but taking tools of trade is premature. You know, hence, I would not put that in a pre-suspension letter, because you are not suspended. The minute I take tools of trade, I have effectively now prejudged, you know, the representations that have not yet been made. It has happened in instances where a person makes representations and then it convinces us that there is no basis to suspend. You know, we can still continue the investigations once the person is at work.
And was the procedure that all suspensions must be preceded by a pre-suspension notification such as this, inviting them to make representations? Was that how it works?
It's like that. It's clause 16 of the collective agreement. Even on the disciplinary regulations for senior managers, clause 5 of the clause 6 of the regulations speaks to that. There must be an opportunity provided to the employee to make representations.
And senior managers in this case would include even chief of police and his deputies.
The chief of police, like I indicated yesterday, you have three categories. Senior managers would be the chief of police, HODs, and the city manager, as per the Municipal Systems Act. And then your divisional heads, like Spies, who was on the same level as I was, would then be the category that is the middle strata. And then everybody else falls under the bargaining unit of the bargaining council, and therefore they are regulated by the collective agreement.
Okay. You know. And you confirm that that pre-suspension process did not happen with Chief Mapie and Commissioner Spies?
I was not involved, Madam Commissioner. I know about the processes, and I've listened a bit to the testimony that both gave. The process that happened is exactly as stated in the collective agreement. I mean, in the regulations for chief of police, provide an opportunity for representations to be made. You know, and my understanding is that that did happen.
Okay.
But what I find fault with what happened is the issue of then taking tools of trade before a determination is made.
Okay. Well, we've heard from Commissioner Spies yesterday that he had attended an arbitration as a witness for the employer, and then it is at that he was told you are on suspension. So it sounds like with him at least, I don't remember Chief Mapie's evidence on this issue, and we'll accept you saying it happened there, but Commissioner Spies seems to have had a completely different experience. Do you have any personal knowledge of that?
Like I say, by the time all of this was happening, I was no longer in the institution.
Okay. No, I remember
but
that.
if it happened that way, it was wrong.
Okay. Thank you. Thank you, Mrs.
Thank you, Commissioner. Mr. Ngiza, we've then wrapped up with respect to annexure PN3. Could I ask you to stay in the annexure bundle and then proceed to the next annexure, PN4, which begins on page 15. Are you there, please?
I'm there.
Thank you.
I'm there, ma'am.
And for context, we're now in paragraph 29 of your witness statement on page 11. Again, my apologies. Please identify the title of the document on page 15.
The title of the document is suspension letter.
Thank you. And the date reflected there, Mr. Ngiza, according to your witness statement, there's a slight correction you would like to make?
Yes. That this is a suspension letter that I drafted on the 24th of February. Unfortunately, it's reflecting 20th February on the letter itself, but it was actually on the 24th of February. And you can also discern that from even the contents of the letter. The letter could not have been drafted on the 20th because the letter refers to an event or process that had occurred on the 22nd.
Okay. I'll take you to that specific part of the letter now, but can you confirm that the suspension letter relates to Mr. Julius Mkhwanazi?
Yes, it does.
Thank you. Mr. Ngiza, the first paragraph of the letter, could I invite you to read that first paragraph, please? Beginning the notice of?
The notice of intention to suspend you issued by the municipality on the 21st of February 2023, as well as your written representations dated the 22nd February 2023.
So we can glean from that first paragraph that Mr. Mkhwanazi made written representations in response to the pre-suspension letter on the 22nd of February 2023.
Yes, he did.
And therefore the date of the suspension letter therefore could not be the 20th of February 2023. Is that correct?
It most definitely could not.
Thank you. In paragraph 2, the letter then responds, or the letter then says, the notice served upon yourself called for submissions of written representations in respect of a determination of whether to suspend you or not. Do you see that?
Yes.
Thank you. Please read the contents of the third paragraph.
The third paragraph,
Yes,
the submissions.
please. Indeed, yes.
The submissions received from yourself do not in any shape or form provide reasons why the employer should not place you on suspension.
And you then cite the authority for that in the next paragraph? Is that correct?
Yes.
My apologies. And in paragraph 5 provides that the employer hereby suspends you from work pending the investigation and conclusion of any possible disciplinary proceedings that may ensue in terms of the provisions of the disciplinary procedure collective agreement. Is that correct?
Yes.
Thank you. And you then set out the reasons there warranting the suspension.
Yes, ma'am.
Thank you. Paragraph 6 then at the foot of the page sets out the conditions that apply in respect of the suspension.
Yes, ma'am.
Thank you. Can I ask you to flip the page then to page 16,
Yes, ma'am.
where I'll ask you to again identify the respective signatures on that page.
The signatures that are on page 16, commissioners, are myself, is at DH Employee Relations, Ms. Linda Kasheka, Acting HOD, Human Resources, and acknowledgement of receipt by J.D. Mkwanazi with his signature and the date that he had received, which is the 24th of February, 2023.
Mr. Ngiza, if I may confirm then, the date of signature of the suspension letter would then be the 24th, correct?
Yes.
Right. And the subject matter of the investigations at this stage is based on a preliminary investigation at this point, is that correct?
Sorry,
Meaning
ma'am.
the allegations under consideration at this point are based on the preliminary, yes, the
Yes.
allegations that make up the subject matter of the suspension at this point are based on the preliminary investigations that have been reported to you at this point.
Yes.
Thank you. All right. Could I then ask you to turn to page 12 of your witness statement? Could we go back to that file? Page 12 of the witness statement, and you are in paragraph 30.
Yes,
Indeed.
I am.
Thank you. And in paragraph 30, you indicate that Brigadier Mkwanazi was suspended for 3 months in terms of clause 16 of the DPCA, that's the collective agreement referred to in the suspension letter, which suspends him from work pending the investigation and conclusion of any disciplinary proceedings. Is that right?
Yes, it was.
Indeed. So if his suspension date was effective from the 24th of February, the suspension would then be effective for the next 3 months up to May, correct?
Yeah, 24th May.
Thank you. Please then take the commission through the subsequent developments after the issue of the suspension letter. You are now at paragraph 31 of your witness statements.
31.
31 on page 12.
So, just for clarity, I need to take the commission, the subsequent developments on this matter of Mkwanazi.
Indeed, following the issue of the suspension letter.
Commissioners, as I proceeded to, of course, deal with my other duties in the institution, which was involving all departments in the institution, but there is an acknowledgement that I've always had that EMPD had the highest number of disputes in the institution, disciplinary matters, I think, because of the nature of the work that is performed by Metro Police officials. You know, they are working with the members of the public, so you would have all sorts of allegations that get raised, whether it's issues of assault, it's issues of bribery, it's issues, you know, that concern the conduct and behavior of the Metro Police officials. So I would then regularly engage with the department on matters that impact discipline in the department. So we had a number of briefings that ensued in respect of especially the investigations in Brigadier Mkwanazi's unit, the investigations into the blue light scandal, but they also raised issues with me regarding other investigations that were underway, inclusive of investigations against Mackenzie, Stolz, and Twala, who were constables working in the specialized unit section. Now, during those briefings that I would receive, I would say that I received what I can only term and describe as horror stories, about what was happening within the unit, and I was kept abreast of even engagements that the chief of police was having with IPID regarding these officials, Mkwanazi, Mackenzie, Stolz, and Twala. So, yeah, I received a lot of information about the cases that were dealt with, issues of copper, theft, issues of even murder, extortion. There's a number of issues that they briefed me about regarding these individuals.
The information you received relating to these three other officers was just as serious as the information relating to Brigadier Mkwanazi. Do you know why they were not suspended or even issued with a letter that requires them to make representations regarding why they should not be suspended?
My recollection, Commissioner, is that indeed they were suspended. There's a point where we suspended them. There's a point where I recall that I even instituted disciplinary proceedings against them. I did institute disciplinary proceedings. I appointed the disciplinary tribunal committee, and the process was to commence. And I later learned that indeed there were problems with regards to the processing of their case. At some point they were arrested, so the action was taken against these three. It's just that it was not taken forward, but my office had instituted proceedings against them. But I understood later on that there was a problem with the presiding officer because he was not paid by the municipality for other matters that he had done for the municipality. So he had served some notice to the attorney to say that he is not going to be able to proceed if he does not get paid for his services that he had rendered to the municipality. That was a big problem, of course, the payment of attorneys for services rendered. But action was taken against these three.
Thank you, Commissioner.
If I may. According to the evidence, so far, the conduct or the misconduct of these three officers came to light because of IPID's report once there was engagement with IPID. Now, internally in the municipality, at least up to the time that you were there, was there a process or a mechanism where employees can report concerns about the conduct of people such as this, the conduct that subsequently came to light through IPD? Was there a mechanism for employees to do that and to do that in a safe way?
The municipality, Madam Commissioner, has a whistleblower policy. I'm the first to admit that it had not been used or utilized by the municipality to its fullest. But the municipality has the whistleblower policy. It's even on the intranet of the municipality. There were campaigns at some point by our communications department to promote accessibility to whistleblower processes. And we've had a number of instances in the municipality where we've had whistleblowers. We investigated the issues that were raised by whistleblowers, and indeed action had been taken against officials on the basis of whistleblower processes. Now, on these specific ones, you are correct that indeed we came to know about their activities as I was briefed through IPID, But what happens is when we've got matters that concern Metro Police officers, you would have two types of investigations. You would have the internal affairs investigation or integrity and standards, and you'll also have an IPID investigation. Now, if you have an IPID investigation, the department would then do a cover letter in that form that says we've got this investigation with its annexures, therefore bring it to me, but I would need something from the department because the department has to take ownership. Even if it's an IPID investigation, the department must take ownership. So then the chief of police will then bring to me a request for a disciplinary tribunal, and in that request they would indicate that here is an IPID report that has a negative recommendation against this officer. So therefore, as labor relations or employee relations, you need to take this forward. There would be that request to initiate disciplinary proceedings against that particular employee. So if my recollection serves me well, that is what would have happened here. They would have provided me with an investigation report, and then I instituted the disciplinary tribunal.
Thank you, Commissioner. Just to close off this aspect of your evidence, Mr. Ngqiza, at the end of paragraph 34, the last sentence then, you confirm that you were informed that in addition to investigating these criminal offenses, the ones discussed above, IPID was also investigating the role of Brigadier Mkhwanazi in the Blue Lights scandal. Is that correct?
Yes, it was.
Yes. And that in the paragraph above, 33, you were informed that even though your discussion related primarily to the issue concerning the blue lights, the IPID discussions had revealed that there was a broader problem involving further police officials, and that was brought to your attention.
Yes, it was.
Thank you. Mr. Ngqiza, we are then beginning a new subheading entitled Disciplinary Tribunal. This is paragraph 35 of your statement. We're still on page 13. Once you are at paragraph 35.
I'm there.
Thank you. Could you please describe to the Commission the developments of that day? Paragraph 35.
Thank you, Council. On the 12th of April 2023, Chief Mapieye, Commissioner Spies, and Lieutenant Colonel Erasmus came to my office, and they presented to me what they term a docket that contained the investigation report onto the allegations that were leveled against Brigadier Mkhwanazi. We went through the report, and of course, I engaged them on the content to say, but, we are talking about this letter of October 2021, what are the issues? And then I approved that a disciplinary tribunal be constituted, because they had, in my view, the investigation report had ticked the relevant boxes that would convince an HR practitioner that there is a basis for this employee to answer to these allegations that have been leveled. So indeed, after we had consulted, I appended my signature to the disciplinary tribunal initiation form, and then we also then discussed how to handle the process. They raised issues with me to say, as much as they had briefed me on several occasions around the matters that concern Mkhwanazi, Mackenzie, Stolz, and Twala. And there was also some process that had started with regards to the other three. They indicated that IPID was confident and convinced that there were imminent arrests that would be made, which would include Brigadier Mkhwanazi. So they requested that instead of proceeding, as much as I've approved the disciplinary tribunal, but I must provide them and provide IPID with an opportunity to conduct these other processes, and then we will then assess the situation. If indeed there are arrests that are made, then it might not be prudent for me to institute an appointed disciplinary tribunal, because there are timelines. The minute you have appointed a disciplinary tribunal, there are timelines that we must comply with in respect of the collective agreement. So we need to play this in a manner that we're able to ensure that we don't incur even some fruitless expenditure, because you appoint a disciplinary tribunal for a matter like this, and then people start working, and then the person gets arrested. You can't even proceed with the disciplinary inquiry and still be expected to pay for the services that you would have sort of incurred from attorneys and the likes. So that was the discussion on the day. And lastly, in the discussion, we decided that they must actually keep the docket because of the contents thereof, and I didn't want it to lie around in my office. I just needed it to be kept in the safe arrangement.
Thank you, Mr. Ngqiza. Commissioners, before we proceed on this issue, I'm going to request that these documents are handed up to you by our attorney, please. They somehow seem to have not made it to the annexure file, but we'll attend to sorting that out over tea. Thank you. Thank you. Yeah, so each of them will get like that. Okay, perfect. Thank you, Commissioners. The documents presented to you are numbered 15A and 15B, and we'll paginate them properly and insert them at the right place in your files. For now, we're going to make reference to them in this course of Mr. Ngqiza's evidence. Mr. Ngqiza, could you confirm that you are in possession of the two documents handed up to the Commissioners? 15A is titled Directive for Implementation of the New DPCA. Do you have that document?
Dated the 15th of February 2018.
Thank you.
Yes, I have it.
Thank you. And then the second document is a document from the South African Local Government Bargaining Council, Circular number 1 of 2008. Do you have that document?
2018.
8th of February 2018?
Yeah,
Thank
I
you.
have it.
Thank you. Thank you, Commissioners. Okay. Mr. Ngqiza, could we then turn to, if we could take a few steps back and return to paragraph 36 of your witness statement, where you say, I concluded that there was indeed a case warranting that a disciplinary tribunal be constituted. Do you see? Can you confirm that?
Yes.
Thank you. If I could ask you to have regard to circular number 1 of 2018, that's the DPCA itself.
Yes, I have it.
Thank you. You'll see that there's an index describing the issues that are regulated by this document. Could I We're
I'm
going,
there.
are you there? Thank you. We're going to focus specifically on clause 7, which relates to disciplinary procedures, in this case, as they regulate a municipality. But I would ask you to please turn to clause 4, which is on page 4 of that document.
I'm there.
Thank you. So clause 4 would regulate the period of operation, right? So the DPCA, as it applies, sets out the period in which it operates. Could you just record for the record what that period is?
On clause 4.1 of the agreement, the period of operation is from the 1st of February 2018, and it will remain in force and effect until the 31st of January 2023.
Thank you. Are you able to confirm to the Commission its status here today? So does it still apply?
Yes, it does, because after the date of 31st January 2023, it then says, thereafter, the agreement shall continue indefinitely in respect of the parties to the agreement.
Thank you. And for completion in respect of this document, the DPCA is the same document that you reference in your witness statement as providing for the suspension. In particular, you cite the letter of suspension cited clause 16. Is that correct?
Yes, it is.
Yes. So the document regulates several processes from a bargaining council level, and we will consider specifically the issue of disciplinary procedures. Is that right?
Yeah.
Thank you. Mr. Ngiza, I'm then going to ask you to turn in the same document to clause 7, which begins on page 5, clause 7.
Yes.
Thank you.
I'm there.
And clause 7 is entitled disciplinary procedure. Could you read into the record the contents of clause 7.1, please?
An allegation of misconduct against an employee shall be brought before the municipal manager or his authorized representative for consideration and decision.
Thank you. And who is an authorized representative in this context, in the Ekurhuleni context, as an example?
Like I said yesterday, commissioners, how we apply this collective agreement in the municipality, we have sort of categorized it. You know, you would have an authorized representative, as envisaged in clause 7.1, would be the head of department. But an authorized representative, as you go on with the collective agreement, would change. You know, it's not a one person. It's not one person. In other municipalities, you might find that it's the municipal manager or this particular person who will be responsible for all the issues that concern a collective agreement. But in our city, we didn't do it like that. We sort of decentralized the processes in terms of our delegations matrix. So in terms of 7.1, it would be the head of department as an authorized representative.
Thank you. See, paragraph 7.2 reflects a principle then that disciplinary proceedings are to proceed promptly without undue delay. Is that correct?
Yes.
Indeed. Then paragraph 7.3 provides that if the municipal manager or his authorized representative is satisfied that there is a prima facie cause to believe that an act of misconduct has been committed, he may institute disciplinary proceedings against the employee concerned. Is that
Yes.
correct? Okay. Could you just briefly explain how that applies in practical terms to the Commission?
In practical terms, this would be, you have an allegation of misconduct that has been received in the department then, in terms of the consideration of the allegation, the department would then institute an investigation. And having instituted the investigation, having then received the outcome of the investigation would show that there is indeed a prima facie basis for you or prima facie cause for institution of a disciplinary process. So then the department would submit to my office once they've made once they've got that prima facie cause, then they would submit. They would not themselves institute the disciplinary process.
Could I ask you to turn to the next page? Clause 7.4, which provides that the disciplinary hearing shall commence as soon as reasonably possible, but no later than 3 months from the date of the municipal manager or his authorized representative's decision to institute disciplinary proceedings.
Yes.
Thank you.
So once indeed the investigation has been concluded and the submission is made in terms of the initiation of a disciplinary process, the authorized representative has got 3 months within which to constitute the disciplinary proceeding.
Thank you.
The disciplinary tribunal.
The next 2 paragraphs then posit 2 options that are available in the event of misconduct. Paragraph 7.5 regulates misconduct that appears to be less serious. Is that correct?
Yes.
Indeed. And then paragraph 7.6 regulates misconduct that appears to be sufficiently serious.
Yes.
Indeed. And what is the course or avenue to be followed according to clause 7.5, where the act of misconduct is one that appears to be less serious?
Where indeed the act of misconduct is less serious, like I had explained, this is an instance where a probable sanction would be a written warning. Therefore, would either have a counseling session or else just issue a written warning to the employee. That is handled as a departmental inquiry. It's handled internally by the department. It does not really require that I establish a disciplinary committee. So that can be handled by the department at a departmental inquiry level.
And where the act of misconduct is one that is more serious, what is the route that is then followed?
The route that is then followed is that the department, having submitted the investigation report, and if indeed, having applied my mind, I consider that indeed this matter requires a disciplinary tribunal, I would then authorize that a disciplinary tribunal be constituted, and having authorized that it be constituted, I then have to move forward to implement the appointment processes for the disciplinary committee.
And those processes are set out in clause 7.6.1. Do you see that, Ms. Anglisa?
Yes.
Thank you. And could you just briefly explain the contents there of who is to be appointed and the alternative appointment that is available in the event that a disciplinary tribunal is authorized?
Thank you, Council. You would find, commissioners, that 7.6 and even 7.7, how it's structured, is it has a default position. The default position in the constitution of the disciplinary committee is that in the first instance, you shall appoint a person internally, And in respect of this, what we did as an institution in my tenure as the divisional head, we had a panel of people that were trained as presiding officers as well as employer representatives. So if we get a request from a department to constitute a disciplinary tribunal, would look at firstly the merits of the matter, what type of case is it, what is involved, the level of the employee, and the likes. And then we would then look at our panel. Are we able to find a suitably qualified person in our panel to deal with this matter? Now,
and you are still talking the default position there.
Yes, that's the default position.
So the panel would be people within
the default position.
The municipality.
The municipality. Our panel is people that we've trained in the municipality. And I need to admit that as much as we had done much in terms of in building the necessary capacity internally, you would find that your senior people from divisional head and HOD level, really do not have time. They simply do not have time. Their demands on their jobs are much higher, and therefore they would not automatically be available or readily be available to firstly go for training. And even if they do go for training, a whole lot of them, even if you appoint them, I promise you, you are just simply not going to get the person to give you time. They've got a whole lot of things. Service delivery imperatives would take precedence. Now, the collective agreement 7.6.1 is clear. When you appoint a presiding officer, the person must be at least 2 levels above the person that you are intending to charge, the accused employee. So you need then to zoom into this particular matter. If you were to appoint a person internally, you would have to appoint an HOD, because the brigadier level, and you will see in the suspension letter, it states that it's a C17. The C17, in terms of our job evaluation processes in the municipality, was the highest level that was evaluated for your bargaining unit employees, for your permanent staff establishment.
I'm sorry to interrupt you, Mr. Ngiza. Ms. Muhlasedi, do we want to discuss the terms of this agreement as generally as we are now, or do we want to zoom in on what was relevant to the case of Brigadier Mkhwanazi?
Thank you, Chair. Yes, our aim is to discuss the 2 of the documents in the context of what was relevant here in 2 respects. Firstly, the constitution, or rather the appointment of an external chairperson and an external prosecutor, which will become relevant during the course of Mr. Ngiza's evidence. The second important issue is who exercised or who bore the power to determine whether to constitute a disciplinary tribunal, and the documents are relevant for that assessment. I will endeavor to be very brief. I'll pose direct questions to
Yes,
them.
I'm asking, for example, because as I understand the evidence here, people external had to be appointed. And I think that focus on the appointment of external people and why it had to be external people should be enough without us getting into the situation where internal people would be used and why. Did you see what I mean?
I follow. Thank you, Chairperson.
Yes, thank you.
We'll
Thank
direct the exchange in that manner.
Thank you.
Thank you. Mr. Ngiza, then my final question with respect to the collective agreement would be in respect of clause 7.6.3. You've indicated then that as a general rule, when constituting a disciplinary tribunal, the effort would be to obtain an internal candidate to act as a chairperson or as a prosecutor. Is that correct?
Yes.
Indeed. And then where that is not available, where an internal candidate is not available or not possible, there are certain circumstances where you would obtain a chairperson or a prosecutor who is an external person.
Yes.
Correct. And in paragraph 7.6.3 reads that where there is a lack of suitably qualified persons or where the presiding officer is threatened or intimidated, the municipal manager or his authorized representative may appoint a suitably qualified external person. Is
Yes,
that correct? Thank you.
Yes, ma'am.
And is it then fair to say that that exception or that alternative applies to the appointment of a chairperson as well as to the appointment of a prosecutor in a disciplinary tribunal?
Yes, it does. It's just that with regards to the appointment of a prosecutor, the collective agreement provides for additional considerations.
And what would those be, briefly?
Whereas the collective agreement does not speak to the presiding officer in respect of legal practitioners, it speaks to legal practitioners in respect of a prosecutor. And the fact that if you are to appoint a legal practitioner, then there should be an agreement between the parties, or alternatively, you should then apply to the presiding officer for the legal practitioner to represent the municipality.
Thank you. But, and just to confirm then, that even with respect to a prosecutor, where a suitably qualified person is not available, or there is an issue, a concern around a threat or intimidation, an external prosecutor may be appointed?
Yes.
Thank you. Mr. Ngiza, I would then ask you to have regard to the document numbered as 15A.
Which one is that?
It's the document with the subject Directive for Implementation of the New Disciplinary Procedure Collective Agreement.
I have the document, but it's not numbered.
My apologies. You can just number that 15A. It shouldn't be, it's all right. We'll handle it for you over the tea break. It's all right.
I'm on it.
Thank you. And just to confirm, that document is a memorandum issued to all HODs and employees, and it cites their 2 unions. Do you confirm that?
Yes.
Indeed. Do you please confirm where the document originates from?
It originated from the HOD HR, Head of Department HR.
Thank you. And the emblem on the top right of the document reflects that it applies to which particular entity, please?
City of Ekurhuleni.
Thank you. And the date is?
The date is the 15th of February, 2018.
Thank you. Which is subsequent to the circular you've just taken the commission through?
Yes, ma'am.
Thank you. Could you just explain briefly what the purpose of this document is and how it is to be considered in light of the circular we've just discussed?
This document talks to the internal arrangements that I had spoken to earlier on, in terms of how we as the City of Ekurhuleni implement the disciplinary procedure that is contained in Clause 7 and other clauses of the collective agreement.
Thank you. Mr. Ngiza, could I ask you to turn to paragraph 5 of that document, please? Paragraph 5.
Yes, I'm there.
Paragraph 5 is entitled, "The following principles shall underpin the implementation of this DPCA."
Yes, ma'am.
Paragraph 5.1 reads, "An allegation of misconduct against an employee shall be brought in writing to the city manager or his authorized representative." Is that right?
Yes, ma'am.
And the authorized representative in this case applies to who? You indicated that it might change in certain contexts, but here, within the context of an allegation of misconduct,
would be the HOD, Head of Department.
And based on our current facts under discussion today, that would be, for example, Chief Mapie.
Chief Mapie, yes.
Thank you.
Continue.
Thank you, Chairperson. Paragraph 5.2 then reads, "A supervisor or another employee investigates the allegation of misconduct and submits the investigation report with a recommendation to the relevant HOD."
Yes, ma'am.
In the context of the facts under discussion today, who would be the supervisor or employee tasked with the investigation of misconduct here?
Under these circumstances, the employee would be Lieutenant Colonel Erasmus.
Thank you. Who you confirmed earlier is from the Integrity and Standards Division. Thank you.
Yes, ma'am.
Paragraph 5.3 then sets out the next step. and it says, upon receipt of the investigation report, the relevant HOD, who I now understand to be Chief Mabandla, shall complete and submit the disciplinary initiation request form to the DH Employee Relations for the initiation of the disciplinary proceedings. Is that right?
Yes, ma'am.
Thank you. So, in terms of this paragraph, Chief Mabandla should then, it contemplates that Chief Mabandla shall then complete and submit the disciplinary initiation request form to the DHER, who is?
Myself.
Thank you.
And critically, it says initiation request.
Indeed.
Yes.
Indeed. And then for completion on this note, paragraph 5.4 says the office of the divisional head ER shall identify and appoint a presiding officer and employer representative. Is that right?
Yes, ma'am.
Thank you. So, Mr. Ngiza, these documents then read together set out a procedure for the institution of the constitution of a disciplinary tribunal. Is that correct?
Yes, ma'am.
With the idea that an allegation is presented to an HOD, who then appoints someone to investigate the allegations and submit a report, and that report is then accompanied by a request to yourself for the initiation of disciplinary proceedings. Is that a fair reflection of the content of the documents?
Spot on.
Thank you. On that note, could I then ask you to have regard to your witness statement again, where we are now on paragraph 38. Paragraph 38, please.
Yes, I'm there. Page 14.
And at paragraph 38, you say there, on the same day, I signed the approval of the recommendation to constitute the tribunal within 3 months. Is that correct?
Yes, ma'am.
Thank you. You make reference there to an annexure PN6. On page 288 of the annexure bundle. PN6.
I'm there.
Thank you. Page 288 of the annexure bundle. I'll just ask you to put your finger there so that we can place the full document on record. If you flip one page back to the front of the document.
On page?
287.
287.
Yes, please. 287, one page back,
Yes.
is the first page of the document, and it is titled Request for Disciplinary Tribunal. Is that correct?
Yes, ma'am.
Thank you. At the top of the page, it is directed to yourself. Is that correct?
Yes, ma'am.
It originates from the Chief of Police, Mr. Isaac Mabandla. Is that so?
Yes, ma'am.
Who you've identified as the HOD referenced in the documents we've discussed?
Yes.
Thank you. The document then sets out that an accusation of misconduct is brought in terms of the disciplinary procedure against Mr. J.D. Mkhwanazi as the employee. Is that correct?
Yes.
Thank you. Importantly, Mr. Ngiza, the document continues to identify the nature of the alleged misconduct, but I would ask you to return to page 288, to flip over to page 288.
Yes, ma'am.
Thank you. Under recommendation at the top of the page,
Yes.
the document provides for two options. The first option, one, is a request for permission to hold a departmental inquiry. And option 2 is a request for the establishment of a disciplinary tribunal. Do you see that?
Yes, ma'am.
Thank you. And at the bottom is a straight line that makes provision for a signature. Could you identify the signatory there, please?
The signature there is one of Chief Mabandla.
Thank you. And just above, as contained in that box, what is the recommendation that Chief of Police Mabandla made or sought and directed towards you?
Chief Mabandla had ticked the second box, which is for a request for the establishment of a disciplinary tribunal.
Thank you. At the foot of the page, you will see then a signature. Could you identify the signature? Who signed there, the signatory?
The signature at the bottom of the page is mine.
And could you identify the content of the boxes just above the signature?
There are 3 boxes above the signature. There is further investigation, departmental inquiry, and disciplinary tribunal.
Thank you. And which of the boxes did you tick in indication of an approval?
Disciplinary tribunal.
Thank you. For completion, Mr. Ngiza, yesterday you engaged with Commissioner Baloy about the options available to the head of employee relations once they receive an investigation report, a so-called docket. And you indicated that there are 3 of those options.
Yes, ma'am.
Having gone through the contents of the collective agreement, you've explained that a departmental inquiry is suitable in instances where the allegations of misconduct are of a less serious nature. Is that right?
Yes, ma'am.
Whereas a disciplinary tribunal is most suitable where an employee is facing particularly serious allegations of misconduct.
Yes, ma'am.
Did that distinction then affect the decision that you ultimately took when considering this request from the Chief of Police?
That distinction always affects the decision that one makes, because you have to weigh the evidence and the merits of the case as presented in the investigation report before you go and tick the box.
And in considering the weighing up of the evidence that was provided to you, you annex, at paragraph 37 of your statement, you annex the investigation report that was provided to you. Do you see that? Paragraph 37 of
Yes.
your statement on page 13, right?
Yes, ma'am.
Thank you. If I ask you to flip over the page, you've then informed the Commission that upon receipt of that report, you considered its contents and then you signed the approval to constitute a tribunal.
Yes, ma'am.
Indeed. And in the paragraph immediately thereafter, you set out briefly the justifications for why you were minded to sign the recommendation to constitute the disciplinary tribunal.
Yes, ma'am.
Thank you. Now, Mr. Ngiza, the Commission has, over the course of the past few days, heard extensive evidence from Commissioner Spies as well as Chief of Police Mabandla about their view as to why the allegations as they related to Brigadier Mkhwanazi were warranted and therefore justified the taking of disciplinary steps. But you also set out in your own view what motivated your decision to constitute that disciplinary tribunal. Could I ask you then to turn to paragraph 39.1, paragraph 39.1 of your witness statement? Are you there?
Yes, I'm there.
Thank you. If I can assist you, please turn to page 36 of your annexure bundle, page 36.
36.
Yes, please.
I'm there.
Thank you. So, to locate this discussion in the context of your annexure bundle, you've annexed annexure PN5, which is the investigation report.
Yes, ma'am.
Thank you. You've confirmed that that is the report that was provided to you on
Yes,
the
it
12th
is.
of April, thank you, and that it is the report that was provided, or rather prepared by Colonel Erasmus. Is that correct?
Yes, it is.
Thank you. You don't need to go there, but on page 21 of the annexure bundle, it sets out a list of documents that are relied upon in the compilation of the investigation report.
Okay.
Thank you.
Yeah.
So if at any stage you require assistance in navigating those documents, I'll assist you.
Okay.
Great. I'll also note for you, Mr. Ngiza, that the docket or the investigation report provided to you is some 250 pages, so it's a comprehensive document. But you've done the task of isolating several documents that you wish to talk through today. Is that right?
Yes, ma'am.
Right. So with that overview provided, could you then go to page 36 of your annexure bundle, page 36?
Yes, ma'am.
Isn't there, Ms. Mutlasedi, a more legible copy of this?
I apologize, Chairperson, that's the
That's the
quality
best
as
we
provided
can
to us.
get.
Yes, indeed.
Is the one on page 54 the same as the one on 36? 54 seems to be much better. Not by much, but slightly.
Thank you, Commissioner. It's larger. That is much better. Thank you. Mr. Ngiza, you've been graciously assisted by Commissioner Kumalo. Please turn to page 54 of the annexure bundle, page 54.
Oh, yeah. Got it.
Thank you. Right. Now, in paragraph 39.1 of your witness statement,
Yes.
yes, you set out briefly there one of the considerations that motivated you to constitute a disciplinary tribunal. Could you please take the commission through that?
Thank you, Counsel. Commissioners, my reflection on this letter was what jumped out, first and foremost, is the usage of two titles. You know, at the bottom of page 54, you find that there is J.D. Mkwanazi with a signature, and then it's Acting Deputy Municipal Police Commissioner / Brigadier. Now, I've been in HR management for more than 20 years. That does not happen. When you're acting in a position, you perform both functions, you know, of the substantive post and the acting position. So if you're going to write a letter in your capacity as Brigadier Mkwanazi, you write the letter and you sign it as Brigadier Mkwanazi. Because the delegations, the authority that are in the position of Brigadier are clearly defined. And you can exercise authority up to a particular point as Brigadier. But then when you are acting in your superior's position, you then assume the delegated authority that resides in that position. So if you're going to write a letter, you must distinguish who is writing the letter. Is it the Brigadier who's writing the letter? Or is it the acting commissioner who's writing the letter? Because then if tomorrow there is there's litigation about the letter.
Mr. Ngiza, but he still was a brigadier, was he not?
He was a brigadier.
Aren't you reading too much then into this? Was he not merely indicating his rank, that he is a brigadier?
With all due respect, Commissioner, it doesn't work like that. It doesn't work like that, you know, because, like I say, different positions carry different authority. So if I am the manager, collective bargaining, and I'm acting as DH, employee relations, if I write a letter that is within the scope of my function, my substantive position as manager, collective bargaining, I would indicate that this, because it talks to my substantive position, But if I'm writing a letter that speaks to the acting position that I'm busy with, that I'm acting in, then I must indicate that. The acting policy of the municipality states very clearly that when you are acting, you perform both roles. You must perform the role of the manager as well as the commissioner.
But would you completely discount the possibility that he could merely have been indicating his rank and nothing more? Would you completely discount that possibility?
I wouldn't completely discount the possibility. It's just that the content of the letter then brings me to this, to say that in my view, this was intended to obfuscate the roles. You know, it was creating this, because at the end of the day, if for instance, I'm to deal with the actions of the employee, and if I'm to say, but you acted outside of your scope, you know, I need to understand exactly in which scope were you acting. Were you acting as the brigadier or were you acting as a commissioner?
All right, I'll leave it there.
Would you have had the same concern if he had signed, as he did there, if he had said Brigadier J.D. Mkwanazi, if that's the first line, because he just says J.D. Mkwanazi. If he had said Brigadier J.D. Mkwanazi, and then in the next line say acting police chief, the way that he has done, would you still have the same concern that you're raising?
Which lines are those?
So that same signature area the chair is discussing with you. So he's got just J.D. Mkwanazi. You see where I'm referring?
Yes.
Okay. I don't know how people sign in the municipality, so my question comes with that, Ryder. If he had said, at the bottom there, if he had said Brigadier J.D. Mkwanazi, so he describes himself, the title and name, Brigadier J.D. Mkwanazi, and then in the next line, he then says acting deputy police something.
Okay.
Sorry, I can't see a thing at all here. Would that still have raised the same concerns that you're raising?
It would have, but perhaps it would have been a bit different in the sense that, remember, and I think that the previous witnesses testified on this, you have the rank of brigadier, you know, and then you've got a post designation in terms of your organizational structures. You know, now if he had said Brigadier Mkwanazi and then said underneath, he'd called himself Brigadier Mkwanazi, and then underneath indicated that is acting deputy chief of police. Again, it still creates the challenge from an HR point of view to say exactly who is signed, but it could easily be dealt with by what we are raising. Say that, okay, fine, it's Brigadier Mkwanazi, but he's acting. So the person who has actually signed is the acting, as opposed to both, you know.
I would understand your point if he had signed as both acting deputy municipal police chief and director of specialized services. But here it's clear that he's referring to only one role, and the brigadier is the rank he holds, and that is the chairperson's point, that it is the rank, whereas the role is that of acting deputy municipal police commissioner. Now, if he had said acting deputy municipal police commissioner / director of specialized services, then that would be different because those are two different roles. But his rank does not change whether he's acting in one role or the other. He remains brigadier.
I get the point.
That's really the chair's point.
I get the point. If you put it that way, I get the point that you're raising. Yeah, thank you, Commissioner.
So I failed in putting across my point.
I get the point. Thank you, Commissioner. So that is the issue that jumped out, but nonetheless, the contents of the letter themselves, you know, the author of the letter says that there is a memorandum of understanding that is signed with CAT VIP. Now, there is no memorandum of understanding that existed between the municipality and CAT VIP. You know, when I looked at the docket, there is no signed memorandum. There is no memorandum that has been entered into. So this is grossly dishonest in my view to say that there is a memorandum when such does not exist. The fact that there is a draft is that it's just simply that it's a draft. There is no actual memorandum that existed. But this letter, makes a representation that there is a memorandum of understanding between this company and the municipality when such does not exist.
Thank you, Mr. Ngqiza. You then make a concluding remark at the end of paragraph 39.1, where you say that this representation or this was intended to clothe this arrangement with some form of regulatory standing where there was none. Is that correct?
Yes.
Thank you.
And that is basically because he did not have the authority to issue such a letter in any event.
Thank you.
So something else in that first paragraph, it may not be significant. He says, the letter serves to confirm that the EMPD, and this is the part that I just want you to confirm the correctness of, under the command of Acting Deputy Municipal Police Commissioner. So as Acting Deputy Municipal Police Commissioner, did the EMPD fall under his command?
No. The EMPD falls under the command of the Chief of Police.
So this
even
is-
if he was not acting.
Yes.
Even if he was not acting. Remember, structurally, the EMPD had various divisions. So the Deputy Municipal Police Commissioner is the head of a division. He's not the head of the department. He's the head of the division. I can't say, as the divisional head employee relations, human resources is under my command. It's not. I'm just the head of a unit. So it was incorrect for him to say that EMPD under his command.
So it was a misrepresentation.
It was a misrepresentation. That is the first misrepresentation right just off the blocks. But then another misrepresentation is made. The misrepresentation about an endless working relationship. Firstly, there is no working relationship, let alone an endless one. He had his working relationship, not the municipality, not the EMPD. What became clear in terms of the investigation is that indeed there was some working relationship, but it's not a working relationship of the municipality with CAT VIP. It is not the working relationship of EMPD with CAT VIP. It is a working relationship that he has constructed, outside of regulatory framework, outside of the policies of the municipality, outside of legislation. He constructed that relationship. And hence, perhaps, he terms it as an endless working relationship because he has every intention of not separating from CAT VIP. Whereas the municipality enters into all forms of relationships, but they are defined. They are defined. There's a process to enter into a relationship, and there is a period of a relationship.
Thank you, Commissioner. Mr. Ngqiza.
Please remind me, Mr. Ngqiza, for whose consumption again was this intended? I see there's no specific addressee. It says to whom it may concern.
That is another a worrying factor, Mr. Commissioner, Mr. Chair, because when you address an official letter, you address a letter to a specific individual or entity. This is addressed to whom it may concern. So the bearer of this letter can then claim that I am the whom it may concern. And therefore, note that I have this relationship with this state entity, and my actions are covered under this letter. It's just too wide, and it has potential to create serious problems. We don't know, even up to today, who actually then had this letter and what did they do with it. I have not come across any information that says the people that got this letter, if it was CAT VIP people, what did they do with this letter? You know, and that's a scary thought that a letter of the municipality can be in the hands of individuals, so that even if they get into a roadblock, even if they get into all sorts of other situations, they will not be checked. They'll just simply say, but we are in a relationship with the MPD. You can't touch us.
And it is, when you say they, it is these vehicles. So this
Yes.
letter lists vehicles.
Yes.
So if any one of these vehicles got into a situation such as you're describing, they would show this and say, I am that vehicle. I'm
this vehicle,
here
and therefore,
working for the municipality.
I'm clothed with this, what you call protection, if you want to call it, but effectively, because I've got this relationship and therefore I work with the MPD and I do these things with the MPD, so who are you therefore to obstruct me? It will be as if you're obstructing police.
Let us adjourn and resume at 11:15. Ms. Mhlasedi.
Thank you, Chairperson. Mr. Nziza, we were in the annexure bundle.
Yes, ma'am.
We were on page 54 of the annexure bundle. And we were wrapping up your discussion as it relates to paragraph 39.1 of your witness statement.
Yes, ma'am.
A concluding question on this aspect. In your exchange with the commissioners, you indicated that one of the concerns you had concerning this document was that it was essentially a bearer document, meaning it applied in the hands of whoever possessed it, and that it therefore purported to bind the municipality to an endless working relationship in that context. Is that a fair reflection of your concern there?
Yes, ma'am, it is.
Thank you.
But just before we stop off, can I just indicate one more concern?
Please do.
This letter, commissioners, if you recall during the lockdown period on COVID-19, you know, we had similar letters, but these are letters that were given to essential services workers for them to go to work. You know, what those letters did is that even if you met the army, the police, and everybody else, you issue this letter, they let go of you. You know, they don't even search your car, they don't do anything. And you would note that, indeed, one of the biggest problems is there's a lot of trafficking of illicit goods. You know, so a person bearing this letter would be able to traffic goods and all sorts of things. You know, this really raised that concern because this was done in 2021, and you know, we were still as a country still dealing with issues that related to COVID-19, and now all of a sudden you've got people that are saying these cars, wherever they move inside and outside of the jurisdiction of the municipality. They have a right to do as they please, so to speak. You know, and that they will not be subjected to the same scrutiny that other vehicles would be subjected to. You know, that was a serious concern as well.
Thank you, Mr. Nziza. In paragraph 39.2 of your statement, paragraph 39.2, we're still on page 14. You then there set out your concerns as they related to the memoranda of understanding as concluded between the municipality and Medicare and the municipality and Cat Security and Protection Services. In order to facilitate your evidence on this score, could I ask you to turn to page 134 in the annexure bundle?
Yes, ma'am.
Thank you. This document was also part and parcel of the investigation report presented to you. Please then, yes, page 134. Please then share with the Commission the concerns you had as they relate to this document on page 134, as set out in paragraph 39.2 of your witness statement.
Thank you, Counsel. The first point of call that you need to appreciate is that as a manager, you operate within a very strict regulatory framework. A municipality is a creature of statute. And as a creature of statute, you know, a municipality functions in a set delegation of authority system. I think this is in terms of Section 59 of the Municipal Systems Act. So you can't willy-nilly have such documents. You simply can't. You know, before you get to the point of generating a document of this nature, there should be a report that speaks to the need that has been identified. Before you even get to the point of crafting a memorandum of agreement or a memorandum of understanding, you should first, as an official of the municipality, working, of course, within that delegations matrix, you should then firstly craft a report that says, in my functional space, these are deficiencies that we've noted. And as a result of noting these deficiencies, there is a need for us, because we do not have the necessary capacity and resources internally, there is a need for us then to engage external sources for us to capacitate the institution to meet these needs. Then that report must then be approved internally in the department by your senior management team. Then the HOD takes ownership of that, submits it to the other structures of the municipality, submits it to the city managers, SMT, it goes to your mayoral committee and the likes. You know, so that indeed the institution then is able to enter into that particular arrangement with an external source. So you can't have a situation wherein there is a memorandum of agreement at any given point that has not gone through the due processes of the municipality. Even an HOD would not have the authority to, out of nowhere, craft a memorandum of understanding with an external source and say this is what is going to happen. So that is the first point. You know, before even going to the content of the memorandum, the existence thereof is questionable. Now, when you then go through the memorandum, the most important thing, remembering that there is a letter that says there is a memorandum that is in existence, you know. Then you go through the memorandum. The memorandum is signed by one person at page 139. And when you look at the signature on page 139 and the signature that we have just dealt with now on page 54, just through the naked eye, without necessarily one being an expert in this particular field, but through the naked eye, you could see that it's the same signature of J.D. Mkwanas.
Is saying that it's questionable, not an understatement.
Sorry, miss.
Is saying that the existence of the MOU is questionable, not an understatement.
It
Because
is.
all that you have is the signature of the person purporting to support, and then thereafter there are supposed to be approvals. And as I look at this, at least two, and there's not a single one. So it was just the person who supported, and that was it. So no indication of approval at all.
There is no approval at all. So you are correct, Chair, that indeed to say that you know the existence might be an understatement. This was not just a mere misrepresentation. It's gross in its nature, because in the letter of October, it says there is a memorandum of understanding that is in existence, when there is no memorandum of memorandum of agreement in existence, because it has never been approved. I think that is without necessarily talking to the issues about the legalities that are contained, but just on that score, you know, from an HR point of view, you can't have a memorandum of understanding, even if it was signed. I need to make this point. Even if this memorandum of agreement was signed by Mzolo and Mapie, in the absence of a report approving it, it cannot be a binding memorandum. It cannot be a memorandum that is owned by the municipality.
But on that, I want to posit this scenario. Let us say there were internal discussions within the municipality involving all relevant role players and the person who would ordinarily have had to prepare the document that you are referring to was also present at those discussions, and agreement was reached at that level. Would there be anything the matter if what then followed was a memorandum of agreement without what you refer to as a document motivating for the MOU? Would there be any problem with what I'm positing to you?
Mr. Chair, we don't work that way. We don't have mere discussions, and discussions result in binding agreements. We are an institution, like I say, we are a regulated entity. And therefore, even if there were discussions, those discussions must then be reduced into a report, which report must go through the hierarchy of the institution. If indeed the delegated authority for approval of that report resides with the city manager, then the city manager must approve, and there must be a letter or rather a document where the city manager has approved. If the approval resides with a committee of council, then it must go to that council. There must be a resolution. Remember, the municipality operates on the basis of resolutions. So in the absence of a resolution, you cannot have an official saying that I had discussions. Hence I was saying, even if indeed Mzolo and Mapie had signed this document, in my view, the document would not have the force of law in the absence of a resolution that permitted the existence of the document.
Thank you. Thank you, Chairperson. And Mr. Nziza, when Colonel Erasmus presented you with this investigation report, the outcome of his investigation, upon your assessment of it, did you ever identify any resolution or any report that purported to give credence to the memoranda of agreement cited?
None at all.
Thank you. Can I ask if there are any further remarks or concerns you would like to identify as it relates to the Medicare memoranda, which you have just been discussing with the Commission?
I think, the issues that that talk to HR processes, I've engaged them. I don't want to actually get into whether EMS was involved, because it talks about emergency services work, and there is no, because at the end of the day, as much as this memorandum purports to be an EMPD memorandum, but the contents of the memorandum itself also talk to emergency services, and there is no aspect in the or rather line where emergency services head was also to approve. I think Commissioner Spies spoke to an issue of red lights being an emergency services function. Now, if indeed you are going to do this, then emergency services must be involved. And you can't have a memorandum that speaks to two different departments that are regulated. Both these departments are regulated. There is legal prescripts that actually regulate how you must do this function as a municipality. Then you conclude a memorandum that conflates the two. It's just, there's just a lot that is wrong with this.
Was any investigation done whether to determine whether any police members of the EMPD utilized this Medicare services that seem to have been intended to be agreed here, and whether any payments in relation to this memorandum or this purported memorandum were ever made by the municipality to this company?
No, Madam Commissioner, I do not recall any such investigation having been conducted. The only thing that this investigation showed is that firstly, we only became aware of this memorandum when the investigation was conducted. You know, there was no evidence of this having been utilized anywhere else. You know, we just became aware because Brigadier Mkhwanazi, in trying to sort of defend himself, raised the issue to say, but I submitted a request for approval of this memorandum and these particular processes. But outside of that, I'm not aware of any
At least
investigation.
as of the date that you stopped working, you're not aware of an investigation done to determine whether services were provided and whether payments were made?
I'm not aware.
Thank you.
Thank you, Commissioner. Mr. Ngiza, turning back to paragraph 39.2 of your statement, you also describe the concerns you have as regarding the memorandum of understanding with CAT Security and Protection Services. Would you please turn to page 141 in your annexure bundle? 141.
I'm there.
Thank you. And what is the title of that document in bold at the top?
It's a memorandum of agreement entered into between the Ekurhuleni Metropolitan Police Department, duly represented, and CAT VIP Protection,
Thank
duly
you.
represented by Vusumuzi Matlala.
Thank you. I'll invite you at this juncture to detail to the Commission the notable concerns you had upon consideration of this document.
The concerns are by and large similar. Both agreements indicate, for instance, on the front page of each agreement, that the EMPD is duly represented by a blank. In both the Medicare document as well as the CAT VIP document. If indeed you are to enter into an agreement, even our contracts in the municipality, a mere contract of employment would stipulate that this contract of employment has entered into between the city of Ekurhuleni and Xolani Prince Nqiza. The city of Ekurhuleni is duly represented by the city manager as per resolution taken on this date, which will be the date that the city manager was appointed. So it would not just simply say duly represented. Any agreement that we entered into, it would say duly represented by this individual, and this individual is empowered by this resolution. You see? So there must be that linkage. So you can't just simply have a memorandum of agreement that is represented by a blank. In this instance, it's a blank. But both agreements in respect of the service provider are represented. The Medicare is represented by Mike Van Veek. The CAT VIP Protection is represented by Vusumuzi Matlala. That's one of the things that you just pick up about the crisis that this thing was. But the CAT VIP one, similarly, you have on page 143 the signature of J.D. Mkhwanazi as the Director of Specialized Services with a date. And interestingly, Commissioners, when one has due regard to the date, that is on page 143, then you look at that in relation to the letter on page 54. This was purportedly signed by Brigadier Mkhwanazi on the 13th. Now, I am aware that Brigadier Mkhwanazi was then appointed on the 15th of October 2021 to act as the Deputy Chief of Police Operations So this purportedly was signed 2 days before he acted in the position. And it's a funny coincidence. He gets appointed to act on the 15th, and then on the 16th, he issues a letter that there is a relationship. You know. And when you look at that relationship is based on a memorandum of agreement that is only signed by himself, purportedly 3 days before he issued the letter. And again, similarly with the Medicare memorandum of agreement, the effective date of these agreements is not stipulated. Safe to say it's some date in October 2021. But the actual date when these things were supposed to come into effect is not indicated. And also, when you look at it, it says /10/2021, then there's a dash, which in my view would depict the intended conclusion date. And again, that is not also stipulated, maybe because it was supposed to be an endless working relationship.
And it's not signed even by Mr. Madlanga.
That's another thing. That's another thing that is also interesting. This one it's a bit worse, because when you look at page 143, you've got support signed, and then page 144, you've got approved by Madlanga. Then 145, you've got approved by MAPA. So this suggests that the person that was to approve was Madlanga before MAPA approved.
Isn't another remarkable anomaly that at 143, the Director Specialized Services, Mkhwanazi, supports. So he's the initiator, right? He indicates, I support this at 143. And then he indicates, as you've said, Madlanga would approve, but I'm more interested in where he's the initiator. And this is on the 13th of October 2021. And then you say he gets appointed on the 15th to be an acting police chief. And then on the 16th at page 54, the person who supported is now the acting police commissioner, and he's the one that's approving what he was recommending. Do you have any comment about that?
Let me start off by indicating, commissioners, that when we craft reports or a memoranda that requires approval, you as the person that drafts the memorandum that requires your boss's approval, you are the recommender. You recommend because you have articulated that this is, you would have indicated the problem statement, and then you would have indicated what is it that you are proposing your superior must do to resolve the problem statement. So then you recommend. You cannot be the supporter. It commences with a recommendation, the person who's recommending. Then, if you're having, like in this situation, Mkhwanazi was supposed to be recommending, Mkhwanazi's supervisor, who was Mzolo, would have then been the one who supports the recommendation. Then the chief of police, MAPA, would be approving. So that should be the line that must be followed. Recommend, support, approve. Now, he says he's supporting when he is the initiator. So that also has got its own issues in terms of the processes in the municipality. But you are correct. It raises eyebrows to say there is a memorandum that is purportedly signed on the 13th, 2 days before he gets appointed to act. And then a day after he got appointed to act, he issues a memorandum saying this is the situation, in his capacity as the acting now, and whereas the person who's in the position, the person who holds the deputy chief of police position, Mzolo, had not supported anything. We do not have evidence of Mzolo supporting, let alone Mapie approving. But when you assumed Mzolo's position, he then says, this is what is happening under my command.
Thank you. Thank you, Commissioner.
Mr. Nziza, I think I heard you pronounce it that way. So the K is not really silent. You say the mover would sign as a recommender and the immediate supervisor would sign as the supporter and the head would then approve. Where would someone like Mr. Makala in this one feature in that process?
And that is one of the things that is problematic. If this was a proper memorandum of agreement, the person that must sign on behalf of the municipality would be the person who must appear on page 134. On page 134, duly represented must have a name. And underneath that name, before the end, you must indicate duly authorized. Duly authorized by council resolution, this and this and that. Now, once you have it that way, Commissioner, at the end, at the signature page, the only person that must be there is the duly represented. Any other person becomes a witness if indeed you are going to have witnesses to the agreement. So the agreement must then be entered into between two people only, the duly represented representing the municipality and the duly represented representing CAT VIP protection services. Those are the people that actually enter into the agreement. Any other person becomes a witness. So the framing of this entire agreement is just totally, out of sync with how the municipality operates.
So what you mean is the signature of the recommender, the signature of the supporter, and the signature of the person approving would all be in the document you referred to earlier, which kickstarts the process. But
Exactly,
once
sir.
you get to the agreement entered into and between, the signatures that you have are only those of the two people concluding the agreement.
Exactly.
Thank you.
So in this instance, if indeed...
So we ought not to have had these signatures at all in this document. So
At all.
It's just a total mess.
At all.
All right, okay, I get the picture.
You mentioned something in your response to the chairperson which raises a different question now. You said somebody signing on behalf of the municipality. Now, these two documents refer to the EMPD as a counterparty. My question to you is, in terms of the prescripts of the Ekurhuleni municipality, does the EMPD have contractual capacity? Can the EMPD as a unit enter into contracts on its own, or must those contracts be concluded by the municipality?
Let's take the example of a supply chain management process to answer you, Commissioner, where there is a tender process that has been engaged upon by the municipality. It's a tender that comes from the EMPD. It goes through your processes of bid adjudication, evaluation and adjudication. Once it's concluded, as much as it is a tender in the EMPD, the city manager then approves the tender. There is an agreement that must then be entered into with the service providers that are appointed in terms of that tender. It is not the chief of police that enters into that agreement. It would either be the CFO or the city manager. You see? So you ordinarily would not have a contractual dispensation between EMPD and a service provider. You would not, But since this thing was not your norm, this did not go through any process of the municipality, and clearly this would not, in my view, it cannot be anything that binds the municipality. It cannot be anything that speaks to the municipality. Ordinarily, as much as it is an issue that concerns EMPD, it will be the city of Ekurhuleni and the service provider.
Well, in fact, is it not fair or so that that documented 134, page 134, it is not an agreement, a memorandum of agreement between Ekurhuleni and Medicare, even on the best generous interpretation. If you look at page 139 clearly is an internal process. So 139 is that page that has support, approved. So that's your internal document, right? Which is the last page attached to the supposed memorandum of agreement. So there's no signature anyway by the municipality, purported by the municipality to create an agreement with Medicare, because this document doesn't do that.
Yes.
Okay. And the same with the one that
VIP.
starts at 141.
Yeah.
It is exactly the same thing.
Exactly.
Thank you. So any services that may have been rendered on the basis of these two purported agreement, we know from the evidence that at one of the state of the city addresses, there were people there who were later identified to have been from CAT VIP protection, that they couldn't have been provided in terms of these, because this is not an agreement.
It's a
between the
non-agreement.
city and a company. Thank you.
It's a non-agreement not only because of the lack of signatures, it's a non-agreement because it does not comply with the regulatory framework.
And the requirements of an agreement anyway,
Yes.
at law.
Yeah.
Thank you.
Thank you, Commissioner. Mr. Ngiza, if we turn back to the memorandum of agreement on page 141, that's between the EMPD and CAT VIP.
Yes.
Thank you. If I could ask you to have regard to page 143, please. Page 143.
Yes, ma'am.
And do you see the effective date there?
Yes.
Yes. Stated as?
It's /10/2021.
Thank you. Could you then tell the Commission what is the date of signature of the Director of Specialized Services at the bottom of the page?
The date is recorded as 13/10/2021.
Could I ask you then to flip the page to page 144 and identify the intended date or so of signature for Mr. Matlala set out there?
The intended date of signature for Mr. Matlala is the 15th of June, 2021. 2022.
Thank you.
Sorry, Commissioners.
And
2022.
Could I ask, what do you make of that difference in between the dates as they regulate the memorandum of agreement?
Again, this is very anomalous. If indeed there was to be an agreement reached, it can't be reached one party signs in October this year, the other party signs some 8 months thereafter. It doesn't make sense unless there is something that was intended by putting this date in. Remember, the date on page 144 is a typed in date. That also creates a problem for me. If this is one document, why would the one part be a typed in date and the other one is a handwritten date in one document and a year apart? if indeed this was one document.
My observation is that this date of 13 October 2021 on page 143 was a poor attempt at trying to regularize the contents of the letter on page 54. Because without this, you cannot explain why you say there's an endless agreement, the source of which is a memorandum of understanding. So he needed this 13 October 2021 date to precede that letter on page 54. That's my observation.
If indeed, if I may be allowed, Commissioner, to take that theory further. When, unfortunately, I'm running ahead of you, Councillor.
Please proceed.
When you look at then the letter of commitment that is now on page 146. The letter of commitment on page 146 of the bundle aligns with the date on page 144. So if indeed this
For the record, which is 15 June 2022.
15 June 2022, the letter of commitment on page 146 is dated 15 June 2022, coming from CAT VIP protection. The date on page 144 of the supposed memorandum of agreement with CAT VIP is dated the 15th June 2022. So if I was to take what Commissioner has raised now as part of this regularization process, my sense is that they needed to do this because this is post the State of the Nation, State of the City address. The 15th of June is post the State of the City address. But now there is a question raised around what happened, So they needed to do this, and unfortunately this is just a hypothesis that one is raising. They needed to then cover their tracks, I don't even believe that this letter was actually generated on the 15th of June 2022. No.
Thank you, Commissioner. Mr. Ngiza, before we turn to the discussion of the letter of intention to commit on page 146, are there any concluding remarks you would like to make as they relate to the memorandum of understanding?
I think we've traversed them enough. I should think I'm okay with what I've said on them.
Thank you.
Maybe one last observation, Mr. Nisa. At that page 143, effective date, you've said that it doesn't say when it starts and when it ends, in fact. Maybe that's consistent with Brigadier Mkhwanazi saying
it's an endless working
agreement.
relationship.
There's some consistency, I guess.
Yeah.
Thank you.
Yeah, you're correct, Commissioner. Indeed, if there were dates that were inserted on page 143, then it would not be an endless working relationship. And remember, this is an endless working relationship with no start date. He doesn't say in his memorandum, this is an endless working relationship that commenced when. And hence, even the effective date on page 143 doesn't indicate effective from when and when is it supposed to end. So, yeah, you don't know. Maybe it commenced on the day that he wrote the memorandum.
And also just one observation relating to the letter of intention to commit. The subject in so many words refers to an intention. Now, and this is on 15 June 2022, as you have said, then one wonders what was happening between October 2021 and 15 June 2022. One would have understood if this letter, instead of referring to an intention, because you can talk about an intention if you have not begun doing that which you intend to do. So it means they are suggesting in this letter that they have not started doing what they intend doing, and that it will be from some point from the 15th of June 2022 that they will start
Going
doing
forward.
whatever it is that they want to do. So I would have understood if this letter said something like, not that it would, what they were doing would have been correct, no. But I would have understood the letter better if it said something like, a recordal of the services being rendered by CAD VIP Security Services. Just an observation. Do you wish to comment on that?
It's spot on, Chair. That observation is spot on. It is one of the things that one had noted to say this talks about an intention. This letter says, I intend to commit. However, Brigitte Mabandla's letter says there is a relationship. So, but Matlala says, no, there's a future occurrence. It's an intention to commit, therefore there's a future occurrence. Whereas Mkhwanazi says there is a living process. It's an ongoing process. So indeed, you are correct, Chair, that the two, I'm sorry, but this was just a form of an disingenuous attempt at covering up whatever people were doing. They knew that their actions they'll be caught out, so they needed to do all sorts of backdating. Because to me, this was just an attempt to backdate, but they were not aligned. They were not aligned. At least they should have sat in the same room and then crafted the two letters from the same room and compare the letters.
Thank you, Chair. In continuing your discussion relating to the letter of intention to commit, you set out further concerns in paragraph 39.3 and 39.4 of your witness statement. Please take the Commission through those.
And I think, Council, what the Chair has raised, in terms of the intention, it's even though I've not captured it succinctly in the statement, but it's an issue, that one considered when now we had to deal with the actual registration of the vehicles, because this letter gets used as a donation letter, whereas there is no donation that the letter says I am doing. It says I intend to commit, and as part of that intention, there shall be a donation. But there is no letter that actually donates in terms of the processes that had happened. So, indeed, this letter again raises the MOA, the Memorandum of Agreement, and that is where the problem starts, because it says CAD VIP Protection, under the leadership of Mr. Vusumuzi Matlala, has signed a Memorandum of Agreement with the Ekurhuleni Metropolitan Police Department. There is no signed Memorandum of Agreement. At least Mr. Mkhwanazi, who gave us these documents, they have not given us a signed Memorandum of Agreement. And we have not, in any of the processes that we conducted that was conducted in the investigation, come across a signed Memorandum of Agreement. So the premise that this thing refers to, the premise that this thing refers to is absolutely incorrect. It's a misrepresentation. It says we've entered into a process that does not exist. And again, it's worrisome that we would have a private company saying that it has intentions of enhancing the state's efforts in crime fighting. You know, this is a private security company, and it says, no, we have intentions to enhance your efforts in crime prevention and to assist in VIP protection. This for me, honestly, it was just a question of trying to plug the gap that they needed to explain about the state of the city address processes.
Mr. Nisa, you detail further concerns with the process in paragraph 39.4.
Yeah. The municipality has a gifts and donations policy. One of the aspects or provisions of that policy is first, before you can receive a gift, the municipality has to scrutinize the donor. We need to find out who is the donor, what standing the donor has, you know, are there any issues that actually as a government entity we should be concerned about the donor, not the donation yet. You know, before you even get to the point of the donation, you have to look at who is the donor. Because you don't want a situation wherein as a government entity you are then aligning yourselves with persons or institutions or entities that are questionable. You know, so that is what the donations policy prescribes. That before you even talk about the donation, let's look at who is donating. So clearly, it would have been unlawful for the municipality to just get a donation without having done its due diligence in respect of the donor itself. Secondly, the donation that is intended. In order, again, Chair, I must emphasize that as a regulated body, a municipality, everything we do must be recorded. It must be recorded. If there is an offer to donate something to the municipality, you know, not to the individual, to the municipality, there must be a report. And in that report, one would have expected that the report would then talk to these issues that are raised in page 146. That report must say, as a municipality, we've got a problem of capacity in terms of our crime prevention efforts. We do not have enough vehicles, we do not have enough capacity, personnel, we do not have the necessary skills and competences, you know, in terms of maybe tactical training and whatever else that is raised here. There must be a report that talks to these issues. You know, if I was Brigadier Mkhwanazi as the person that is in charge of specialized unit, the specialized unit, mine was then to do that assessment of our capacity, submit a report to the senior management team of EMPD, you know, and ask that we as EMPD approach council for council to provide us with the necessary resources to plug the gap. That's where you start. You don't start by going to some company outside and then you got all sorts of arrangements. You don't. If indeed this thing is above board, if this thing is done honestly, you know, you must submit a report. Identify the gaps, identify all the challenges that we're facing, then make recommendations on how to plug this. But the default position is that to ask council to provide with the capacity. Council, if indeed this is an issue that requires the municipality to get funding, council will then take a resolution to submit something to National Treasury to assist. We are a government. We're a government. So All these issues that are raised in this letter, these are things that should first be dealt with internally in the municipality.
Are you suggesting that there can be no donation if there is no gap that's sought to be plugged?
That's just the thing. Why are you donating to government?
Assume that
out of nowhere.
Assume that I'm a billionaire and I want to donate to you a few billions for service delivery.
Well, I don't know, Chair. I mean, if indeed such a situation will arise, but still would need a report. In everything that we do, there must be a recordal that indeed this was identified or this person approached us and wants to enter into this particular partnership or wants to donate these resources to the institution. Because they are contingent issues that arise out of a donation, especially a donation of an asset that is to be utilized. You as the donor, you'll give the municipality this vehicle. But once the vehicle now becomes an asset of the municipality, the vehicle must be funded by the municipality in order for us to use it. You must make sure that there's petrol, tires must be changed, all sorts of things. So now your donation, nice as it is, creates a burden on the municipality. Because now we must service it, we must do this, we must do that. So we must create funding that will not come from you, but must come from the coffers of the municipality in order for us to utilize that donation. So that report must talk to those issues. That report must talk to those issues that if we accept this donation, these are the contingent issues that then come with it, that we will need to get funding. So therefore, finance must then identify a vote number that will be able to be utilized for the purposes of us accepting the donation and therefore be able to utilize it going forward.
Thank you, Chair.
Does council have a role in the acceptance, in the decision to accept
Yes.
or reject a donation?
It does.
Okay. How does that come about? What happens? You make a submission?
A report.
Okay.
Everything, unfortunately, requires a report. The report then goes through the structures. The report, of course, will go to other departments that will be involved. It's a donation to EMPD. Fleet department must be able to make their own comments on the report in terms of how this particular asset will be utilized. Finance department must be able to make their comment on the funding for the utilization of that particular asset, and then it goes onto the structures of council, especially, this type of donation, these are easily going into millions. Vehicles of this nature would probably go into millions in terms of their value. Then council must be in a position to take that view, having, of course, done the due diligence around the donor, but council must resolve to accept the donation.
Thank you.
Thank you, Commissioner. Mr. Ngiza, in addition to the issue you've raised about a lack of a report, can I ask you to have regard to paragraph 39.4 of your witness statement? Paragraph 39.4. In the second sentence of paragraph 39.4, you raise a further concern. Please detail that to the Commission.
Now, you have this letter of commitment, and then we get to learn that the donation was effected. And I'm saying effected, or the donation in quotes, and effected in quotes as well, in January, by way of the cars registered under the municipality. But the Jeff Wicks query, media query, does not reflect these cars has been utilized by the institution. They were registered. Sorry, commissioners. I don't know why this
you
thing
can
is
tell them you're in the commission. They must not disturb you. You're talking.
No, it's my 12 o'clock alarm for prayer. I pray at 12, sorry. I'm sorry about that. It's one of the things that I want to switch this thing off. Done. Right. Apologies.
No need for an apology. In fact, you should have prayed for all of us.
Any time, Commissioner, anytime. So you have the so-called donation occurring in January 2023 by registration of the vehicles unto the municipality. But the media query from Jeff Weeks conclusively shows that these vehicles were utilized by the donor. So there is no benefit that the institution then derived from the donation. I make the example, Commissioner, that if I'm to give you my laptop and donate my laptop to you, and then we input your details on the laptop so that the digital footprint is Madlanga, but then I retain the laptop. I continue to use the laptop. So if tomorrow there are issues that arise out of the laptop, the digital footprint will say, well, Madlanga's laptop did this, But I continue to use the laptop, so whose laptop is it? So was there a donation? No, there was no donation. Because if you donate something, you must hand it over. It then becomes that person, the beneficiary's asset. But in this instance, there was no handover. Actually, we did not even know about the donation until the media query. So, yeah, that is one of the issues. There was no handover. And in that 2 months period where these vehicles were under the municipality's name, we don't know exactly what would have happened or what happened, what type of transactions, these vehicles were used in. What is it that was ferried through these vehicles? We don't know that. But what we do know is that if these vehicles encountered any form of scrutiny by any law enforcement agency, that law enforcement agency probably would have said they are municipal vehicles and therefore let me back off. And
is it fair to suggest that perhaps the registration period, January to, and then deregistration, well, the donation period and registration period and deregistration from you may well indicate or may suggest that in that period, that cover that is provided by the municipality may well have been required for a specific purpose, because they get registered in January or given to you Jan and registered and then deregistered March. So it may well be there was a specific purpose for it, and once it was achieved, the vehicles were then deregistered.
I can only postulate, Madam Commissioner, that had it not been for Jeff Weeks, whatever the purpose was would have continued. Because the deregistration process happens as a result of Jeff Weeks. Remember, we didn't know as a municipality. So if Jeff Weeks then didn't raise the alarm, whatever it is that the vehicles were doing would have continued. I don't know for how long. So it might be that indeed there might have been a purpose, an underlying purpose why this scheme was generated. But that underlying purpose could not have been for the shortened, because we're talking about a month and a half from around the 18th of January to the 6th of March. So we're talking about a month and a half or so, wherein these vehicles were registered under the municipality. So whatever the scheme was, it's probable that it was a much larger intention than much. Because the evidence that we gathered shows that when now Mkhwanazi gets suspended, then he then raises the issue with Fleet to say, hey, let's give me the documents, let's do the deregistration process, because the donation process is cancelled. So, yeah.
Maybe those epaulets should have been given to Mr. Wicks then.
The what?
Maybe those epaulets and Georgettes should have been given to Mr. Wicks.
We owe him a huge gratitude.
It sounds like. Thank
We
you.
owe him a huge gratitude as an institution. We don't know exactly what the name of the municipality would have been taken through. I mean, can you imagine a situation wherein indeed any of these vehicles gets entangled in some criminal activity and the law enforcement agency that is dealing with that criminal activity picks up that this vehicle is an Ekurhuleni vehicle? It would then have meant that our vehicles are used in a criminal enterprise.
Thank you.
Yeah, it's depressing to even think about. But what I also raised in 39.4, commissioners, is another serious concern. All things being equal, if these vehicles indeed were registered under the municipality, properly registered, and the donation process had been properly done, and assume that these became municipal assets. Because now, on the 18th of January, the vehicle, BMW, is now on the system an Ekurhuleni asset. If that had been done, and we were to accept that a donation had occurred, the process of deregistration raises even another problem. Because now you have got a municipal asset. There is a process that you must go, you must now invoke in order to dispose of a municipal asset. Because once these things are now in the register of the municipality, and I'm not suggesting that they were in the register of the municipality, they were just on the innate system, but they were not on the register of the municipality. But the fact that now they are called Ekurhuleni Metropolitan Municipality vehicles, they are now assets of the municipality. In order for you to dispose of a municipal asset, again, you need a report. You need a report, and that report goes all the way to the municipal council. And council must then resolve that such asset must be disposed of. An asset like a motor vehicle, and I'm raising this because a number of reports had existed where indeed motor vehicles would be disposed of by the municipality, can only be disposed of via a public auction. If the municipality wants to dispose of an asset, it must advertise such a disposal process and call upon members of the public to come and bid in a public auction for them to buy that asset. Remember, this is an asset of society, because government exists for the people. So then the people must then be given an option to gain that asset. We do that even with regards to land, So this instance, you have a municipal asset that is now disposed of without following due process again.
Thank you. Mr. Ngliza, in your earlier exchange with Commissioner Baloyi, you mentioned the name of a Mr. Steyn. I'm going to ask you to turn to page 156 of your annexure bundle, please. 156 of your annexure bundle.
Here we go.
Yes.
I'm there.
Just in order to provide context to you, Mr. Ngliza, we are still dealing with the contents of that investigation report that was provided to you. And one of those documents is this one, titled Memorandum on the top left. Do you see that?
Yes, ma'am.
Thank you. Please identify to the Commission who the document is from.
The document is from Mr. Chris Stein
you. And
from
it is-
Fleet Department.
Indeed. And it is directed to?
Chief Mabandla.
Thank you. And the subject of the document is?
Donation of vehicles.
Thank you. Please just describe to the Commission what is fleet, what is the role of fleet management in the municipality before you go through the letter.
Commissioners, we have a department in the municipality called Transport and Fleet Management. That department has got two critical roles. In respect of the lack of transport, they deal with the regulatory framework for public transportation within the jurisdiction of the municipality. Your buses, your taxis, and the likes. That unit deals with basically that. Then fleet. Fleet is now internal transport arrangements. All the vehicles of the municipality, from buying vehicles, services of vehicles, repairs. Even when a vehicle is involved in an accident, fleet gets contacted, they come. So they become the custodians of the vehicles of the municipality. Everything that concerns vehicles, fleet are the people that must deal with it. Yes, ma'am.
Mr. Ngliza, could I ask you to look at paragraph 2 of that memorandum? It starts in December 2022. Do you see that?
Yes.
Could I ask you to read that, please?
In December 2022, Director Mkhwanazi from EMPD came to see me about a donation of vehicles to EMPD. I indicated to Director Mkhwanazi that the licensing department are closing for December holidays and that he has to come back in January 2023.
Please continue.
In January 2023, I indicated to Director Mkhwanazi that there must be a letter of donation from donator to EMPD. In January 2023, Director Mkhwanazi brought me the documents and vehicles registration documents to me at my office in Primrose. They be registered in COE as per donation. I gave the documents to my admin representative to register the vehicles as per donation to EMPD.
Thank you. In paragraph 4 of that letter, Mr. Stein continues to set out, Mr. Stein explains his position then in response to the request from Mr. Mkhwanazi. Could I ask you just to explain to the Commission what he says in paragraph 4?
Well, it says Mkhwanazi is a senior officer who approached him, Stein, with a donation letter, and he didn't see anything wrong. And all he requested was a formal letter on the donation of the vehicles. And he takes the view that indeed a donation would assist EMPD as the department are currently struggling with low enforcement vehicles. Then he says this is the norm, as my understanding as SIT program, Caesars program, and Gauteng heavy vehicle donations were donated only on a donation letter.
And what does he continue to say there in paragraph 5 in February 2023?
In February 2023, Director Mkhwanazi contacted me and informed me that the donation is cancelled and he will send people to collect the documents to change it back to the donator.
And the final paragraph of that memorandum, paragraph 6.
Then he said, see attached letter of donation from CAT VIP Protection and Memorandum of Agreement.
Thank you. Now, Mr. Ngliza, could Mr. Stein rely on the documents mentioned in paragraph 6 in light of the concerns that you have expressed to the Commission this morning, in particularly as they relate to the letter of donation?
With all due respect, it's mind-boggling that Stein would write this letter. It just Firstly, he says he relied on the letter that is on page 157 to page 158, which is the letter that we had dealt with earlier on from CAT VIP Protection. The letter is even unsigned. And again, the letter is an intention. There is no actual letter where CAT VIP is donating. You know, even if indeed this so-called norm existed, which I refute, such a norm does not exist. It couldn't exist in a government institution, that a simple letter would effectively generate financial implications for the municipalities, as I've earlier explained. But nonetheless, his reliance on the letter as well as the memorandum is just,
mind-boggling, as you say.
Yeah, it's mind-boggling.
As you say.
I mean, none of the documents that he refers to are signed by anybody. I mean, the memorandum is supposedly must be approved by MAPA, but it's not approved by MAPA. You know, the memorandum of agreement is not approved by MAPA. Madlanga has not signed his letter of commitment or so-called donation letter. You know, so even if I was to give him the benefit of the doubt, that would have to be premised on signed documents from authorized people. None of the documents that he gave to the investigator actually have got anybody's signature.
But also that letter of intention to commit that he says he relied on doesn't even specify the vehicles. It just says BMW, Mercedes-Benz, Volkswagen Golf. How does he know that whatever he's given, these are the vehicles?
You know, honestly, commissioners, because this is an issue that we had raised, and of course, there was an intention that this must be taken up with Fleet for them to investigate Chris's actions in this particular regard, because this simply didn't cut it. It can't.
Did anything come of that intention for Fleet to instruct Fleet to investigate? Did anything happen?
Not to my knowledge.
The Fleet Department and the Licensing Department, are they part of EMPD or are they a separate division?
Licensing Department is part of EMPD. Fleet is different. Fleet is Fleet and Transport. It's a separate. Remember, Fleet looks into the entirety of the fleet arrangements in the municipality for all departments. You know.
Thank you, Commissioner. Mr. Ngliza, if you have regard to paragraph 5 of Mr. Stein's memorandum, he details there that he was contacted by Director Mkhwanazi and informed that the donation is cancelled. Do you see that?
Yes.
Thank you.
Can I just comment a bit?
Yes, please do, particularly with
Yeah.
reference to the concerns you've expressed about proper cancellation as opposed to deregistration in this context.
Commissioners, firstly, paragraph 4, Stein is effectively saying, I took Mkhwanazi's word. Okay, fine, I've got these documents that are unsigned, but I mean, I was approached by Mkhwanazi, who's a senior EMPD officer, and I didn't see anything wrong. You know, so effectively, I didn't concern myself with due process. I didn't concern myself with council policy and processes. The fact that this senior person came to me sufficed for me to process this thing. Essentially, that is what he's saying. You know, then on this one about cancellation, even then, if indeed these vehicles were now registered under the municipality on the basis of the donation letter, and let's assume that the donation letter was proper, and it had followed all due processes. How do you then effect processes to cancel on the basis of a simple phone call? I was contacted. I'm not sure whether he went to him or he phoned him, but the bottom line is there's nothing, there's no paperwork. When he was supposed to do the registration, he said, give me the donation letter. And he got the donation letter and did the registration. But now when there's a cancellation, he does not demand the cancellation letter. You get my point? For the one to come in, I require something, but to go out, it's fine, let it go out. That is also disconcerting. That is a rather very blasé way, a manner of dealing with municipal processes and what would have then become a municipal property. Then he just gave him the documents to cancel.
Aren't these policies, for example, the donation policy, what is involved, what is the process, and the approvals required, are those things not widely available to employees?
They are on the intranet.
So every employee...
And they've been there. For instance, the donation policy, Madam Commissioner, has been on the intranet. I mean, this is a policy, if I recall, that was approved way back around between 2006 and 2008, around about then.
So you would expect that Mr. Steyn, who receives donations and he makes reference to heavy vehicles and other donations, that he would be aware of that policy and what it requires?
It is obligatory of him to be au fait with the policy.
Okay, thank you.
Thank you, Commissioner. Mr. Ngqiza, that's then your final sub-paragraph under paragraph 39, where you were taking the commission through the factors that motivated you to sign the approval to constitute the disciplinary tribunal against Director Mkhwanazi. Sorry. Are there any further remarks or concluding remarks you would like to make on that topic?
Well, I think I've remarked enough. I've remarked enough.
Great. And in that case, then please have regard to paragraph 40 of your witness statement. We're on the same page. And so having made that decision to sign, you set out there the subsequent developments in that meeting of the 12th of April. Please take the commission through that.
Yes, Commissioners, this was an alarming issue that was raised in that meeting. Remember, I testified that Chief Mapia and his team would brief me on a regular basis about other investigations that they had been working with IPID on, or they had been informed by IPID. Then they raised this one about an investigation that IPID engaged them on regarding a murder of a shop owner, which they suspected that it was an extortion gone wrong. And again, the names of the three officers were raised with me, Mackenzie, Stolz, and Twala, as well as the involvement of Brigadier Mkhwanazi in respect of this particular matter, to do some form of cleanup of the scene and disposal of the body. They raised those issues, and indeed,
Mr. Ngqiza, up to this point, the witnesses who came before you avoided mentioning the names, reason being they were not quite sure whether the officers had actually appeared in court. You've already mentioned them now. Perhaps going forward, if you could also just avoid a repeat of that.
Apologies, Commissioner.
No problem.
Yeah, so they mentioned several EMPD officers who allegedly took part in the torture and the murder, as well as the disposal of the body. And they then indicated that in terms of their engagements, the chief's engagements with the executive head of IPID, there was a sense that there is some imminent arrests that would be made by IPID that involved colleagues in the EMPD, inclusive of the brigadier.
Please proceed to paragraph 41.
We then, of course, having received that information, we then discussed the challenges of now we've approved a disciplinary tribunal. What then? If indeed there is these processes that are underway, how then do we move forward? We engaged, and the sense that the chief provided me is that perhaps let us provide IPID with an opportunity to do their work and indeed effect the arrest, because it would impact the processing of the disciplinary process should we immediately institute the disciplinary proceedings. My judgment call that I made at that particular meeting was to say, in terms of the collective agreement, from the date that I've made a determination to the commencement of the disciplinary hearing, I've got 3 months. So I took the view that indeed let me afford the department that latitude in terms of working with IPID and dealing with the issues that they need to deal with to deal with the criminal aspect. Once that criminal aspect has been dealt with, then I can then engage on the HR issues.
Mr. Ngliza, you set out in paragraph 41 some of the concerns you had about immediately proceeding to constitute the disciplinary tribunal. Could you please expound on that?
The issues that I've reflected on. Firstly, indeed, at the point when we took a view that a disciplinary tribunal must be constituted, and looking at the level of the employee, and of course what I had explained earlier on this morning about the default position in terms of the collective agreement and the panel that I had at my disposal, the complexity of the issues that pertain to this matter, the potential for victimization of your internal disciplinary committee, we took the view that indeed we might require that we get legal representation. Now, if indeed I'm going to appoint attorneys to deal with the matter, or even instruct an advocate to deal with the matter, from the moment that they receive their appointment letter, they start working on the matter, and now you'll find that they work on the matter and then the matter is not able to proceed because people are arrested, so it would not actually assist the institution. Perhaps let's await, because we do have this period in terms of the collective agreement. Let's let those other processes unfold so that indeed we appoint a disciplinary committee at the appropriate time, and then we're able to process the disciplinary hearing in a manner that will ensure that the hearing itself continues and it gets finalized.
And in the course of that meeting, what was then resolved? On what basis did you conclude a way forward? Paragraph 42.
The conclusion that was reached was that, firstly, I made the decision that I will not constitute a disciplinary hearing immediately, but I would constitute it within the period that is envisaged in the collective agreement, which is within 3 months. in light of the fact that there was this possibility of arrest. We also agreed that Chief Mapie would regularly liaise with IPID for updates and also update me so that indeed I'm kept abreast, and then I can be in a position to make a considered view on the appointment of the disciplinary committee. We also decided that for security reasons, remember, commissioners, at this point, unlike other matters in my unit, I would involve my managers that reported to me. I had a unit that actually deals with discipline management, but at this point I had not involved them. I honestly had kept this matter, especially given the other issues that were also involved. I kept it with myself, and I only dealt with the Chief of Police, Spies and Erasmus, and no one else regarding it. So I then took a view that if this docket remains in my office, it can have a potential of being exposed to other individuals within my unit. So we then decided that Erasmus must keep the docket because he had a safe in his office where he keeps sensitive documents. So we decided that let him keep the document, the docket, and then secure it at his premises, at his office and the likes, so that indeed we do not incur any breach of the process that we're involved with.
And on the basis of that resolution, that then concluded your meeting of the 12th of April.
Yes, ma'am.
Thank you. But turning to paragraph 43 on page 17, please detail to the Commission the events subsequent to that meeting.
All right. Now, of course, we would have these engagements with Chief of Police, almost on a weekly basis. But what was becoming clear is that IPID is not making the imminent arrests that they had promised. So in May, the middle of May 2023, Erasmus approached me. I think it was one of the instances where he would come to my office and to deal with ongoing investigations. And then he indicated to me that, hey, there's a problem that we're going to encounter because Brigadier Mkwanazi's suspension was going to expire on the 24th of May. So there's a likelihood that then he would then come back, and we have not processed this discipline. So I advised him to say, if as a department they feel or they've got evidence to suggest that indeed Brigadier Mkwanazi's return would interfere with witnesses and would interfere with the running of the disciplinary hearing, the envisaged disciplinary hearing, then they should motivate. They should do what we normally do. It's a process that we have been engaging in for a while in the municipality, where indeed a department then would submit a motivation that would be signed by the head of department and address it to the head of department, HR, Kashega, of which, of course, they then did.
Please then continue to paragraph 45 and 46.
Yeah. So we did indeed receive the extension request from the Chief of Police, and I discussed it with Kashega, the HOD HR, and she agreed. She agreed that indeed we shall effect the extension of the suspension. And that request was provided to Kashega on the 22nd of May 2023. On the night of the 23rd of May 2023, I saw that on my WhatsApp I had a missed call from Dr. Mashazi, the city manager. This would have been because the timestamp on my phone still has it as 1813. And then I would have called back Dr. Mashazi about 30 minutes thereafter, around 1845 or so. When I called her, she picked up the phone and she just came at me. Raised the issue of the extension of Mkwanazi's suspension. That, yeah, you guys hate Julius. You and your friend, Chief Mapieye, you hate Julius. You know, we must leave Julius alone. You know, I'm like, no, what is this about? No, Julius, you're not going to extend his suspension. When Akolani, you must stop this thing of yours. Like, how? Firstly, I explained to her that, but firstly, I don't take decisions about suspensions or extensions. You know, mine is to advise upon receiving a request from a department. Mine is to advise the person that must take that decision, which is Tashega. You know, well, she was like, no, you are lying. You are the one that take these decisions. Linda just simply signs. Okay, but that's not how the process works, you know. And I was told that I was targeting Brigadier Mkwanazi. I was personal towards him. And Commissioner, honestly, this was not a calm discussion. My boss is effectively shouting at me and lambasting me. Then she told me during that particular call that when unahana or masipala wa hao.
Please translate that for our...
You think this is your municipality? Yeah, like, I don't understand. How do I think this is my municipality? Yeah, you think you can do anything you want in the municipality. My attempts, of course, of trying to calm down Dr. Masazi didn't succeed. She was genuinely angry that there was even an attempt or even talk of extending the suspension of Mkwanazi. Now, she indicated that, of course, she's going to call Trashega to deal with this and tell Trashega that Mkwanazi must be back at work the very next day. At the end of the call, she instructed me to facilitate the return of Mkwanazi to work. And I must update her by 11 a.m. the next day that Mkwanazi is back at work. I've known Dr. Masazi since 1999, when I was in the trade union movement. I met her at Springs when she was a manager in the health department. I had never experienced such hostility from her. You know.
I just want to understand something. So this is now May 2023.
Yes.
Up to that point, your discussions were with Chief Mapieye and the head of HR. You had never discussed the Mkwanazi issue with the municipal manager.
We did. Remember, we discussed the Mkwanazi issue with the municipal manager on the 16th of February.
In Feb.
You know, when we briefed her that we are going to engage in a process to investigate the allegations as per the Jeff Weeks media query, and also if potentially institute disciplinary proceedings, you know, and also suspend Mkwanazi. All of that was discussed, and we had her support on the 16th. After the 16th, I had never discussed the issue with her because there was no need insofar as I was concerned, because my processes, you know, are clear. You know, now this comes in my. This came out of the blue, you know, came out of the blue, and I interacted with Dr. Maswazi on a number of issues. I would be in her office, she would contact me. At no point was there ever even a request for an update to say, by the way, how far are you? What's happening there? Nothing. So you could imagine that I've never had a discussion with Dr. Maswazi after the 16th of February. Now the 23rd of May comes this call, and at the end of the call, I am told that Liamutluhela Julius, you leave Julius alone. So, yeah, it was quite a shocker. It was quite a shocker, and I don't know, should I proceed?
Before this incident, had Dr. Maswazi ever intervened in a disciplinary matter with you directly?
Yes.
In what circumstances?
Yes. It was not at the level of a disciplinary hearing. In 2017, there is a case that had arisen in our communications and also, customer relations management department, CRM, where the head of department at that time had caused an investigation to be conducted against the activities of a divisional head. Now, when that came to Maswazi's attention, because that head of department had requested Security and Loss Control Unit of EMPD to conduct this investigation about nepotism and all sorts of other problems regarding a contract management. When that came to Maswazi's attention, she then instructed that we can that investigation, and at that point, the investigation report was out. We can that investigation and don't appoint a disciplinary tribunal. And then she instructed me to draft a new directive on how investigations are to be conducted in the municipality. And that directive was to the effect that no investigation shall be conducted against a divisional head without the city manager being informed and the city manager approving. Now, I did not have a problem with that concept or that particular principle because divisional heads are not covered by the DPCA. So I did not have a problem with that. We crafted that. But she stopped a disciplinary hearing from proceeding, even though we had not yet appointed.
In this case, in the case of Brigadier Mkhwanazi, she, other than to say you're being personal and that stuff that has nothing to do with the merits of the of the disciplinary action, did she provide a reason based on the merits of the suspension itself?
The entire conversation, at no point was I asked, as the custodian of discipline management processes in the municipality, whether there was a basis, in my view, for the extension of the suspension. And remember, at this point, we're not even discussing the actual investigation report. There's not even a question about it. I was not even given an opportunity to raise the fact that I actually have an investigation report that says something is wrong. And therefore, this employee must be disciplined. That does not arise in this conversation. This conversation was a vitriolic attack on me, on Commissioner Mapie as the Chief of Police. It was a very personal engagement. It had nothing to do with municipal processes.
When you spoke to her in February, where you say she supported the proposed course of action, did you explain what the nature of the allegations, even if not in detail, Did you explain to her the reason why suspension is a likely path that you are taking? Did she
Yes.
become aware of all of that explanation?
We explained that these are the allegations. We explained the media query. We explained the Madlanga connection. We explained the issue of the registration of the vehicles. We explained the issue of the operational plan, that we were not even aware that there was CAT VIP involvement in the state of the city address. She expressed shock because she was the city manager even at that time. She was also not aware that there was CAT VIP that was involved in such in that particular state of the city address. So we explained everything, and honestly, she responded like what a chief executive officer would do. The allegations of serious misconduct, investigate them, suspend the employee, ensure that your processes are implemented.
Did you ever become aware, or do you have a possible explanation why the change in her position from the seriously supportive, as you describe, in February, and this kind of engagement and instruction to discontinue? Did you ever come to know why there's that change, or at least have a view about what would explain such a drastic change to the other extreme?
I can only express a view because I do not have evidence of it. But what became clear, even when I engaged the chief, remember, in February, when we took a view that let's go and engage her, one of the things that the chief raised with me was the proximity between herself and Mkhwanazi. So the only thing that in our assessment we could come to is that Mkhwanazi would have gone to her to indicate that this is what is happening. And therefore she intervened because there would have been a request. Because in terms of EMPD, nothing official had gone to her office. In terms of HR, nothing official had gone to her office. In terms of Tlashega and my engagements with Tlashega, there was nothing. So the only person that would be a factor in this entire situation would be Mkhwanazi. There is no engagement with chief, there is no engagement with HOD HR, and at this point there's no even an engagement with the legal HOD. At this point, the only person that in our view would have had that particular access, would have convinced her to take this posture, is the person that is the subject of the telephone call.
Does your answer suggest that when you spoke to her in February, Mr. Mkhwanazi had not spoken to her? Because my question is really about that you have at the beginning support, and then later on you have the opposite, in fact, that undoes that support you had. Does your answer suggest that in February, when you did the first approach, Brigadier Mkhwanazi would not have spoken to her at that time?
Exactly.
All right. Thank you.
Thank you, Commissioner. Chairperson, I'm noting that it's just a minute before 1. It might be an opportune moment for lunch.
Let's adjourn and resume at 2 p.m. Ms. Mahlasedi?
Thank you, Chair. Mr. Ngisa, just to confirm, you're still in possession of your 2 files?
Yes, Council.
Thank you. We were at paragraph 48 of your witness statement on page 18. Paragraph 48.
Yes.
Indeed. Just before the lunch break, you gave testimony about a telephone conversation between you and the city manager, Dr. Mashazi, where she told you in no uncertain terms, "Limutlogele Julius," and directed you to facilitate his return to the office.
Yes, ma'am.
Thank you. In light of that evidence, I wanted to pose a few questions to you, particularly in light of our discussion this morning concerning the collective agreement. In terms of the collective agreement, Mr. Ngisa, which official in the city has the power to suspend and extend suspensions of employees?
Thank you. Commissioners, like I indicated yesterday, how the system works is that the municipal manager has got the overall authority, but then the municipal manager has appointed an authorized representative. So the authorized representative will then be seized with the process of suspensions, will be the head of department HR, Ms. Linda Klasheka. So as much as the municipal manager has overall authority, the person seized with the process would have been Linda Klasheka.
And so in circumstances where Ms. Klasheka was seized with that authority, on what basis did the city manager act when she intervened and instructed you to facilitate the return of duty of Brigadier Mkhwanazi?
It's a tricky one because in the absence of a submission by the municipal manager that goes to the merits of the suspension, because the municipal manager has a right to say that, but the merits of this suspension are poor, and therefore I do not agree that this person should be suspended. So on the basis of that, where there is a rational disposition that exists for the municipal manager to intervene based on the merits of the case, then indeed one would say that the municipal manager then would be within her rights to then intervene and stop a suspension. But that was not the case in this instance. You know, as Madam Commissioner had previously asked, whether indeed there was a discussion on the merits, there was none. So that disposition then would not apply in this instance, where we would expect that a municipal manager would deem it fit to intervene.
So when the municipal manager says, "Limutlogele Julius," did you understand that to relate only to the suspension or the entire process? In other words, the investigation and the initiation of the disciplinary process and the appointment of the panel, as you said. What did you understand that to mean, Limutlogele Julius?
At that point in the discussion, this is before, of course, other processes that would then follow subsequent to this discussion. The discussion was narrow in the sense that it was about Julius coming back to work. There shall be no extension of the suspension, you know. So in a narrow sense, one just took it that this is about the suspension. And therefore, let me just leave it at that. There was no specific instruction issued regarding the disciplinary case itself.
The reason I'm asking you this is if you go 6 paragraphs back in paragraph 42, you say, after the discussion amongst ourselves, I made a decision to constitute a disciplinary tribunal.
Yes.
Now, let's go back to my question. So it's not just the suspension, it's also the constitution of a tribunal and other things. Now, when she said to you, Lemotlogele Julius, did you understand that to mean don't extend the suspension but continue with the constitution of the tribunal and other things?
I understood it to mean don't extend the suspension. You know, remember, I have never discussed with the city manager the issue of the constitution of the disciplinary tribunal. You know, even during the course of this conversation, there was no engagement about the disciplinary tribunal at all. You know, and like I indicated, this was like she came down at me regarding the suspension. There was really no angle or even an opportunity to engage to say, but there is this other aspect. That was not her concern. Her concern was Julius must come back to work, so to speak.
Thank you, Commissioner. Mr.
Sorry, in the absence of what you've described as a rational explanation for why the instruction, Lemotlogele Julia says she wants her back at work tomorrow, is it not, if you spoke frankly and freely, is it fair to describe it as a simple abuse of authority and power?
It was not a simple abuse of authority and power.
No, what I'm saying is...
This was abuse of authority and power in the extreme.
Okay, yes, thank you.
You know, especially where there is not even an engagement on the merits. Why the extension? There's no... If the conversation had gone along the way of saying, I understand that you intend to extend this suspension, can you give me the basis of that? See, then you would say that there is a rational engagement. You know, now that you've given your superior, your boss, the basis, the boss says, no, that's not sufficient for you to actually do this. Then if it had flown that way, one would say, you know what, the municipal manager acted in accordance with what we'd expect of a chief executive officer. But in this instance, it was not.
Thank you, Commissioner. Mr. Ngiza, please then go to paragraph 49 and detail those events to the Commission. Paragraph 49.
Now, you can imagine after the call was dropped, my first instinct was to get hold of the head of department. Remember, I'd been in this journey with Chief Mapie since he came back from leave in February. And there'd been numerous engagements between us regarding this particular matter. So the first instinct was to get hold of him and to relay that, hey, Munna, I've just received this call. Unfortunately, I could not get hold of him. His line was busy. But then eventually, he called me back and relayed that, hey, Munna, I've just received this call. Instead of me relaying to him that I've received this call, he started off and went at me to say, hey, Umama has called me. And this is what she's telling me, that Julius must be back at work tomorrow. Of course, he was displeased. And then I indicated to him that I also received a similar call. And in sharing our notes over the call, exactly the same thing happened to him as it had happened to me. The basis of the instruction is that we're personal, we hate Julius, there is nothing wrong with Julius, he must come back to work clearly in Totsarun.
Please then continue to paragraph 50.
And given the fact that indeed the person that must make the determination to extend or not is Lasheka, I tried to get hold of her. And unfortunately, I could not. And I mean, this is now around about 8 or past 8 at night. I could not get hold of her that night. However, the next morning, when I checked my phone, I discovered that Ms. Klashega had responded to me at around 10 to 1 in the morning.
Mr. Nriza, perhaps I may assist you. If you turn to page 289 of the annexure bundle, your 289, that is annexure PN7.
Thank you,
Perhaps
Counsel.
you can give that evidence with reference to the page.
Thank you, Counsel. On page 289, indeed, on the 24th of May 2023, recalling commissioners that my engagements with the city manager were the previous night, just before 7 p.m., and I tried to get hold of Ms. Klashega, and I couldn't. Then she sent 2 messages to me. The first one at 0049, so sorry, I had a load shedding, electricity just came back now. And then at 0050, she said, please draft a letter for Julius Mkhwanazi is resuming duties today. I hope Chief contacted him.
And you then responded to say?
Because I had received these messages, I saw them in the morning when I woke up. At 6:32, I greeted her, good morning, HOD. And then I said, I spoke to Chief, the letter will be ready when we meet. And then in response to, of course, to a load shedding message, I said, unending crisis, like everybody was experiencing load shedding.
Thank you.
Is that if you know that this is wrong, and Chief knows that this is wrong, and the HOD knows that this is wrong, why do you go along with it? Is there no grievance procedure within a Ekurhuleni municipality that allows you to say the municipal manager is unlawfully interfering in a process? We want to report this thing.
Okay.
Are you not making the situation worse? I mean, you know what the allegations are. You saw how serious they are. There was a report of somebody being murdered. Knowing all of that, the 3 of you just agreed to draft a letter. He will come back to work. We will move on with our lives. I don't get that.
Yeah. Perhaps let's try and respond like this, Commissioner. I received the call that gave the instruction. I don't agree with the instruction, but nonetheless, it's the instruction of the Chief Accounting Officer. My first point of call is to talk to the department. The department has received the same instruction. We are both unhappy. But recall now, the person who actually has the authority to extend or not extend is Klashega, not us. At the end of the day, Klashega is the one that must make the determination, whether to extend or not to extend. We try to get hold of Klashega. I don't get hold of her. But when I wake up, I find that Klashega has already issued the instruction that he must come back. So the sense that I had is that clearly Klashega would have engaged with Mashazi. Maybe after the 2 calls to me and Mapie, Mashazi would have called her. The engagement would have happened between the 2 of them. Then Klashega issues the instruction for me to draft a letter for Mkhwanazi to come back. Now, even if I was to submit a grievance, the only type of grievance that I can submit in terms of the grievance procedure in this instance would be a grievance to the executive mayor. Now, I'm not the one that actually would be submitting such a grievance because I'm not the one who must actually make the determination on whether there is an extension or not. The person that must make the determination, if she has agreed, and I'm not privy to the actual discussion that happened between Klashega and Mashazi. But Klashega instructs me to say, draft a letter for Mkhwanazi to resume work. Mine is to then draft that letter. I agree with you that indeed it was wrong. It was wrong in terms of the instruction itself was wrong because it did not have a rational basis. But at the end of the day, the person that was supposed to stand up and say, no, it's my authority. You are now usurping my authority, and therefore I will not do that. I have been briefed by my divisional head. I've been briefed, or rather the department had motivated, and my divisional head has briefed me, and I have agreed with the extension, and therefore I stand by my decision to extend. That was the duty of the HOD HR, who is seized with the power to extend.
What did she say is the reason to do a letter for that instruction to you? Did she explain anything to you?
When we met in the morning, because I went directly, instead of going to my office, I went directly to Germiston in the morning as I was instructed to facilitate. So I would not have facilitated this process from Benoni. I went to Germiston and I engaged Ms. Lashega on the content of the conversation that I had with Mashazi the previous night. And she also indicated that she also received the same call. Now, what I'm going to say to you might be a bit of a shocker, but it was the norm. It was our experience. Xolani undingxolisile lo mama. Andifuni ukuthi uMashazi mina yenza le letter. Xolani, this lady has shouted at me. I don't want to be further shouted at. Do the letter. I'm saying it was a norm because every instance where something has to happen in the municipality and HR must do something, if you have an issue, you will be told that I don't want to be shouted at by Mashaz.
All right, thank you.
Thank you, Commissioner. Mr. Ngiza, you are then at paragraph 51 of your witness statement, where you make certain remarks or conclusions on this intervention. Can I invite you to share those with the Commission, please?
Yes. I make this remark here, Commissioners, because this was not the first time that we have a situation where there's an extension of a suspension, and it certainly was not the last. There is a gentleman that we had suspended who was at a divisional head level. That person was suspended in May 2023. An investigation of sorts was being conducted in the department. At the end of the suspension period in August 2023, Lashega instructed that a letter be composed to extend the suspension. And we've got a number of other instances where suspensions in the municipality would be extended, either because the investigation is still underway, or at times the disciplinary proceedings have commenced but have not been concluded, and then a view is taken that indeed the suspensions be extended. So the manner in which this was handled was out of kilter with how others were handled.
And so you're saying in that example in paragraph 51 that even in the context of a suspended employee where the allegations against him were at that stage still preliminary, an extension of the suspension was granted and the employee was directed to continue staying away from the office?
Yes.
Yes. Viewed as against the case of Brigadier Mkhwanazi, where the formal internal investigation was completed and a docket was already submitted to your office, and yet the extension of the suspension was not granted.
Was not granted.
Thank you.
And remember, the point of the matter is the non-extension, so to speak, had nothing to do with the actual facts of the case.
Can I then allow you to conclude on the subject with what is stated at paragraph 52, my apologies.
Yeah, I don't know whether I'm allowed to just correct the statement.
You're welcome, please.
Yeah, I think, commissioners, I think my use of the word endangered witnesses is a bit strong, and I would not be in a position to actually support that. But I would rather say that this intervention potentially compromised witnesses. Because that is one of the key issues that you don't want to see happening with regards to a discipline management process, that your witnesses get compromised as a result of the active presence of the accused employee in the institution. So this potentially compromised witnesses of the municipality, the documents that would have relied upon at the hearing, and even the integrity of the disciplinary process itself.
Those were the very reasons that you put for suspension.
For the suspension in the very
decision.
first place. In my view, those reasons still existed. Not only my view, but also the view of the department. Those very reasons still existed at that point.
Yes.
And would you then agree, Mr. Ngiza, that the very risk you were attempting to prevent, the risks identified in paragraph 52, the efforts to prevent them through the use of the suspension were undermined by the upliftment of the suspension?
Yes, ma'am.
Thank you. Right. Thank you. Can I then ask you to turn to paragraph 53 and detail the events of the 24th of May? Paragraph 53.
So after I had met with Ms. Lasheka at the office, and we had agreed that indeed we will do the resumption of duty letter. I mean, to do such letters, there's a template, so you would just craft it. It's a quick thing. I had to leave her office and go to what is called the administrative precinct. The office would be, if it's on this side, the administrative precinct would be where council is sitting, and then the government precinct would be where you are sitting as commissioners. So her office is this side, left, then straight. So I had to go to the administrative precinct, where the city manager's office is located. There is a huge parking lot in between. There are two parking lots, actually. So as I was walking towards the administrative precinct, I ran into Brigitte Mabandla in full uniform, at the parking lot. We greeted each other, and then he indicated, as per what is on paragraph 54, tried to engage me to say, no, Olani, these guys signed documents that they are now accusing me of, so like, no, these guys have signed, but they want to fire me for what they've already signed. So I avoided the engagement. I was like, okay, yeah, into Zakon. I didn't want to engage. Remember, I was aware of what is contained in the investigation report, and as a matter of principle, I do not engage with employees that are the subject of either a disciplinary hearing or investigation on the contents of that particular process. So I was like, no, just downplayed it, and he was on his way to see Lasheka at the time. And I just politely sort of disconnected and went on my way, and I didn't want to engage him on the substance of the matter.
Please proceed to paragraph 55.
Now you have a situation on the 24th where Mkwanas is back. I engaged the chief of police to say, okay, fine, now what? what is the plan in your department in terms of how do you handle this situation? He indicated that, no, it's fine, he's back, but I've redeployed him. I don't want him in the unit where all of these things were happening. I've redeployed him into bylaw enforcement because that position was vacant at the time. And of course, the basis upon which he wanted to redeploy talks to what I have raised even on paragraph 52, ensuring the integrity of the disciplinary process, is kept. So that was his concern. And I later learned, not on the 24th of May, but sometime in June, that another intervention had come about to direct that Mkhwanazi go back to his substantive position of Director Specialized Services.
Thank you. And therefore that the efforts of Chief Mapie then to try and keep Brigadier Mkhwanazi outside of his original station were unsuccessful.
Yeah, they were unsuccessful, because at the end of the day, the municipal manager, gets involved. She gets involved, even though the letter itself that actually directed that Mkhwanazi must go back was from Tlashega. You ask yourself even how does Tlashega get to know that Mkhwanazi is deployed to another unit instead of his former station? So there was just this pressure that was put on Chief Mapie that, you are going to do this thing our way and not the municipality's way.
Mr. Ngiza, with reference to paragraph 56, at some point in May of 2023, it becomes clear to you that the imminent arrests are not so imminent. Please then tell the Commission what steps you took thereafter.
Now, this is after the 24th of May. I engaged with the chief, I engaged with Peace and Erasmus, and the view is then taken because for me, my processes still need to run. I have no instruction from anyone that says the process that I've approved in April should not run. So I then engage them, and the view is taken that I must now constitute the disciplinary tribunal. My 3 months is running short. We are already left with less than 1.5 months. So we then took that view that indeed I must now process what you call the disciplinary tribunal, let alone the issues of the suspension, because the suspension, was dealt with. It is for me, honestly, it was a closed chapter. I was not going to concern myself with the suspension. I need to deal with the disciplinary tribunal at this point.
And if I take you back to paragraph 56, in addition to your concern that IPID was not going to arrest anyone anytime soon, you detail there a further concern that you had about the dynamic in the work environment, I would say.
Yes.
Please.
It was clear. It was clear how the matter of the suspension was handled, that Mkhwanazi was being protected by Tlashega and Mashazi at that point. It was clear to me that, in respect of how the suspension was handled, that was the situation. But I still needed to ensure that my process is carried through.
To your knowledge, Mr. Ngisa, did the city manager or Ms. Tlashega become aware of the IPID investigations? Were they, as far as you know, did they become aware of that at the time that you were given the instruction to withdraw the suspension? or not to extend the suspension?
The IP investigations.
Yeah.
My understanding at the time is that Chief Mapia had informed the city manager that there was an IP investigation into Mr. Mkonazi's activities. But the extent of that at this point, because you see, there's a lot that happens post-May. At this point, the extent of her knowledge, I would not be able to say at this time in May.
Thank you.
Thank you, Commissioner. Mr. Ngiza, we're then at paragraph 57, where you've explained to the Commission your decision to move ahead with constituting the disciplinary tribunal. With reference to that, your second sentence in paragraph 57, please just explain what factors motivated the appointment of external lawyers there.
As I had indicated, in terms of how the collective agreement is structured on the default position, now, when I look at the default position of appointing a person to preside that is a level or 2 levels higher than the position, it meant that I would have to appoint a divisional head or an HOD. Now, there were very few divisional heads and even less HODs that were trained to be presiding officers or even prosecutors. So already we've got a very limited scope. Secondly, experience has been proven that in that very limited scope, people are very busy. They simply do not have time. And that had been reported to the municipality on numerous occasions, that it would always be a challenge to get a divisional head to reserve time and not deal. For instance, one of the people that would have been appropriate for the appointment would be a divisional head in the water services department. And you're having all these challenges with water services, and then you expect this guy to go and sit in a disciplinary hearing for a week. It's just impossible in the municipality. That is a consideration that talks to the complexity of the situation, but also the complexity of the situation in terms of the merits of the case. Where such that when we are dealing with matters or charges that would involve issues of gross dishonesty, a person that would have to sit at such a hearing must have an acute understanding of the policy regime that governs these processes, that were involved here. And then also not only the policy regime, but also these legislative issues that would come into play when we are discussing, or rather when we are busy prosecuting a case of this particular nature. So those complexities play a fundamental role in terms of a determination that must be made on who to appoint within the limited scope. So then it became clear to us that we would have to get external legal services for us to be able to deal with this matter. As well as, of course, the potential, given the totality of what was at our disposal in terms of the information on issues that Brigadier Mkonazi was implicated in, besides just the blue scandals, blue light scandal, the blue light scandal. That will be a nice one. So besides the blue light scandal, so you then have to look at.
Maybe it's there somewhere.
No, so you'll also have to look at. It's only responsible for a person who's head of a labor relations environment where you've got more than 20,000 employees to make decisions that would not only benefit your process but also benefit those that are connected to your process. The potential for victimization or even harassment of the very same people that will be the disciplinary procedure, disciplinary tribunal committee. There is that potential that we must look into. And given what we had in terms of the activities of this individual, and those that are connected to him, it would not have been a rational decision for me to insist on having internal people dealing with this matter, quite honestly. Hence, we then took a view to appoint the external legal representatives.
Thank you. Mr. Ngisa, can I ask you to turn to page 290 of your annexure bundle?
Yes.
There.
I'm there.
Thank you. You set out in paragraph 58.1 one of the appointments that you made.
Yes.
Yes. So can I ask you to take the commission through that paragraph with reference to this document?
Yeah, I appointed Madlanga Attorneys, which is a firm of attorneys that is on the panel of attorneys of the municipality. And in the appointment, I mandated them to brief Advocate Sandile Sibisi, to prosecute Brigadier Mukanazi.
Is it necessary to mention the names? Is it not sufficient to just say a firm of attorneys and counsel?
Fair enough, we can do that, Commissioner. Mr. Ngisa, in the course of giving evidence as it relates to the two appointments that you made, are you able to do that without direct reference to the individuals involved?
Sure.
Thank you so much.
So I appointed a firm of attorneys that is in the panel, and I requested them to brief an advocate, I think he's in the Johannesburg bar, to prosecute the matter and to prepare the charge sheet.
Can I then ask you to go to annexure PN9, which is on page 291 of your annexure bundle? Okay. And
similarly, in line with the determinations that were made in respect of the appointment of the prosecution team, I then appointed a firm of attorneys that is also on the panel of attorneys of the municipality, and I requested them to brief an advocate who would then be the presiding officer in the disciplinary tribunal.
And having constituted your tribunal now through these two appointments, please explain from paragraph 59 the subsequent developments following those appointments.
Just as a matter of note, commissioners, in both appointment letters, you will note that there is a line that says, please note that the internal official responsible to this matter is Mr. Ngisa, with the landline telephone number in both instances. So then ordinarily, a matter would be allocated to a labor relations officer or a labor relations manager. But in this instance, like I had said initially, I wanted the matter to reside with me in my office. So I then communicated with the firm of attorneys and directed them to say that this is a matter that is in the EMPD, and therefore they would need to be in consultation with the EMPD in order for them to get, as much as there is a docket, but also to get witnesses that will be in a position to testify on the matters that were contained in the docket, and which would also assist them in the process of drafting the charge sheet. So yes, I indicated that. And then I don't know whether I should just continue with how the entire process.
Please
unfolded.
proceed. I'll ask Mr. Ngisa that when you give the identities of the individuals involved in preparing the charge sheet, you'll omit the names of those engaged by the law firm. Thank you.
So indeed, there were numerous individuals from the department who then got involved with the preparation of the charge sheet. Of course, given the nature of the allegations, the process itself became a bit more detailed than what one had initially anticipated. You know, there were several engagements that were held, and I was involved. Persons from the firm of attorneys were involved, and then the investigator that compiled the investigation report, which is Erasmus, and then I involved at this stage. It's when I then decided that I would also need to involve the manager in my office that deals with discipline processes, because now it is at a stage where the actual facilitation of the disciplinary tribunal must take place. And in most cases, I would not have sufficient time to be involved directly with the actual disciplinary hearing. Yeah.
Yes, please proceed to paragraph 61.
The charge sheet was at a later stage amended in order to include additional charges. This would have been around about the 19th of June, when there was an indication, 19th, 20th June, when there was an indication that indeed the charge sheet did not include matters that pertained to the operational plan. And therefore the charge sheet was then amended, and eventually the final charge sheet was supplied by the firm of attorneys on the 20th June 2023.
And that charge sheet is annexure PN10, which is found on page 292 of your annexure bundle.
Yes, ma'am, it is.
With reference then to the charge sheet, Mr. Ngiza, you've indicated that it contained 6 charges.
Yes, ma'am.
Correct. The heading at the top of page 293. Could you please read that text highlighted in bold at the top of page 293?
Charges: failure to conduct yourself honestly and thereby infringing the disciplinary procedure collective agreement.
Thank you. And you confirm that's the document we went through this morning?
Yes.
The DPCA, thank you.
Yeah.
Mr. Mngza, I won't ask you to read the entirety of the charges into the record. We've attached them for the attention of the... We've attached them for the attention of the... My apologies. Okay. I won't ask you to read the entirety of the charges into the record. We've attached them for the convenience of the commission, for the benefit of the commission. What I will ask you to do is to take the commission through, sort of a summary of a charge as it's set out there.
Thank you, Council. Commissioners, the charges that are set out relate first and foremost to the memorandum that we dealt with of the 16th of October 2021 that spoke about EMPD being under the command of the brigadier and all the endless working relationship, where indeed we were alleging that even the crafting of that particular memorandum amounts to gross dishonesty on the part of the brigadier. And then you have the charge number 2 basically speaks to the issue of the memoranda of agreement, the 2 memoranda of agreement between, purportedly between the EMPD and CATS Security Services, as well as Medicare 24.
emergency services. Again, the issue here is about gross dishonesty because the allegation is that the brigadier had made it seem as if there is indeed a memorandum of agreement that was entered into between the parties. And he placed reliance on that order that caused other people to place reliance on that submission. And then number 3 effectively deals with the registration of the 4 vehicles onto the municipality's name, which will be dealt with in terms of the processes that he engaged with Chris Stein and them and got those vehicles registered under the municipality. And again, the allegation is that this amounts to gross dishonesty and abuse of the resources of the municipality, as well as his position of authority. The 4th charge is about the implications of that memorandum that was issued. That effectively means that people can impersonate police officers, because they would have a memorandum on the letterhead of the municipality that states that these people are having this working relationship with the municipality, and therefore, as people that are working with the municipality on these specific issues, those people can then be taken to be members of the Metro Police Department, and indeed, by extension, those people can then be taken to be allowed to use blue lights because of the impersonation of a law enforcement official. Again, the allegation is that indeed this amounted to abuse of his position and gross dishonesty, and as well as abuse of the resources of the municipality. And then the 5th charge relates to the issue of the donation in terms of the report that he had submitted to Commissioner Spies. In the report that he had submitted, he speaks to, I think it's the report that contains the titled cartels. That report, he speaks to a donation that he had solicited and received to the value of 300,000 rands. So this, again, is about the non-observance of your council processes, your council policy and the likes. Again, this amounted to gross dishonesty, abuse of the resources, insubordination, and abuse of the position of authority. And then the last charge is the one that is now talking to the operational plan. And the argument here is that the operational plan that was submitted by Brigadier Mkhwanazi in February 2023 pertaining to the state of the city address, was altered and therefore constituted a fraudulent document that he had submitted.
2022.
2022, yes, state of the city of 2022. Thank you, sir.
Thank you.
Yeah, so those in essence were the charges, the 6 charges.
Thank you. And Mr. Mnisa, if I might just turn your attention, for example, to charge 6 on page 294. The last sentence there reads, your conduct amounted to a violation of clauses 1.1, 1.2.3, 1.2.4, and 1.2.5 of the DPCA.
Yes.
Do you have, are you able to give the Commission a sense of what those clauses in the DPCA relate to?
Yes, Commissioners, the DPCA, which is, I don't know what is it marked as.
15.
15.
B. 15B?
right at the end of the DPCA, I think if you look at the numbers, at the bottom where there's the initials, page 24, the DPCA has got an annexure. After the collective agreement has outlined all the procedures, then it has an annexure.
Just to assist you, Mr. Ngiza, so we're all on the same page, you've directed us then to 15B, that's
Yes.
Circular 1 of 2018, the DPCA. You've asked the Commission to turn to Annexure A on page 24, is that right?
Yes.
Thank you.
Exactly.
Please continue.
So whenever you draft a charge sheet, and these commissioners have experienced not only in Ekurhuleni but in other municipalities where I've been called upon to assist with discipline management, you have to, in the charge, put, having outlined what is the charge, then a prosecutor would ordinarily put which clauses of the standard of conduct the employee has violated. In labor relations nomenclature, this would be what rule has been broken. So the first one, and you will see that in almost all the charges, there is a consistency, 1.1, that there's an expectation to comply in every respect with the conditions of employment and collective agreements and any related regulation, policy and practice of the municipality, and to refrain from any conduct which would give just cause for discipline. So that is a standard that the prosecutors had put, that this, what Brigadier Mkonas had done, give rise to, or rather give rise to a just cause for discipline. And then 1.2.3, perform their tasks and job responsibilities diligently, carefully, and to the best of their ability. So effectively, the charge also talks to that. All these charges say, in what the brigadier had done, there was no adherence to a diligent performance of one's tasks. 1.2.4, obey all lawful and reasonable instructions given by a person having the authority to do so. Clearly, if a person is going to go and do things that are outside, the policy framework, that is a person who is not obeying instructions. 1.2.5, conduct themselves with honesty and integrity. So that is what effectively the prosecutor had crafted as a case of the municipality against Brigadier Mkonas, that his actions are in contravention of the disciplinary procedure collective agreement in relation to that standard of conduct.
And Mr. Ngiza, if we stay in Annexure PN10, which is the charge sheet, if we turn to the last page of the annexure.
Sorry, before we go to PN10, the documents you have marked 15A and 15B, should they go into Annexure PN4? Where exactly are they supposed to go in our bundles?
Under Annexure 15, Commissioner.
PN15?
Correct.
Oh.
Correct.
Yes, ma'am.
On page 296,
96.
Mr. Ngiza, that is the last page of Brigadier Mkonas' charge sheet. There's a paragraph there drawing attention to the engagement of a prosecutor to initiate the proceedings. Do you see that?
Yes, ma'am.
Thank you. At the bottom of the page, bottom right corner,
Yes.
where it says confirm receipt.
Yes, ma'am.
What purpose or what utility does that section of the charge sheet serve? What is ordinarily meant to be recorded there?
When you serve an employee with a charge, you need to certify that indeed this person has been served. And the best way to certify that the person has been served is for the person to acknowledge your receipt of the charge sheet. So what would happen is, when you serve, you would have two documents. You would have the charge sheet and a copy. Then you'll give the employee, and then the employee must sign on the copy that indeed I have received this charge sheet. So that even when you go to the actual disciplinary hearing, the presiding officer can satisfy himself that there's proof of service on the employee. That is the standard.
And was there in fact proof of service on the employee? Was this charge sheet served?
No, the charge sheet was not served.
No. Can I then invite you to paragraph 63 of your witness statement?
So, on the 20th of June, Commissioners, the final charge sheet that all the parties involved were satisfied with, and I'm saying all the parties involved critically for me, the case in a disciplinary inquiry must be made out by the department. So it's important for me that the department is satisfied with the charge sheet, because it is the department who are the witnesses, it's the department who are the experts on the policies, on the procedures that must be followed in the department. So when I say the parties, critically it is the department that had also confirmed that indeed they were satisfied with the charge sheet. Then I instructed Mr. Zitsamba, I instructed my manager to then process the serving of the charge sheet as per the norm in my office. So the manager then came back. I think the final charge sheet was emailed to my office. It was just before 1. It was just before 1. Then he had called, or that he came back to me and reported that he had called Brigadier Mkwanazi and indicated that he wants to make arrangements for the service of the charge sheet on him. However, Brigadier Mkwanazi had informed him that he is not going to come. He's not going to meet with him, and he's not going to accept the charge sheet. And the reason why he was not going to do that was because he, Brigadier Mkwanazi, had instructions from Dr. Mashazi, the city manager, as well as Ms. Trasheka, the HODHR, not to accept the charge sheet because that case is not going to fly. Not only did the manager indicate that conversation with Brigadier Mkwanazi, but there was a further conversation that he had immediately after having spoken to Brigadier Mkwanazi. Indicates that he was then called by the personal assistant of Ms. Trasheka, who informed him that Ms. Trasheka has instructed that he must not even attempt to serve that charge sheet on Brigadier Mkwanazi. So that's why the charge sheet was not
never
served.
served. And Mr. Ngliza, in your engagements with the HR manager responsible for the service of the charge sheet, did he ever relate to you the basis for that intervention? So on what authority or on what basis did the city manager and Ms. Trasheka direct that the charge sheet should not be served, or that the brigadier should not collect the charge sheet?
Well, he did not have a basis. He did not relay a basis because he just indicated that he was instructed not to serve, and there was no reason provided to him. Instead, he was miffed. He was like, but what is this now? Since when are these individuals part of our process? This is an ER process. You have appointed a disciplinary tribunal. Now all of a sudden you get calls that we must not do our work.
And what did you say to him in response to that? So after he updated you about his challenges with serving the charge sheet, what was your response to him?
Given my experience the previous month regarding the non-extension of the suspension, I had a sense that, something is afoot here. So I requested him to just simply record in an email what has happened and to inform the prosecutor.
And all of this happened without Ms. Kasheka speaking with you? Did
No.
she not speak to you at all?
No one spoke to me. No call from Mr. Kasheka, no engagements with the city manager.
Yes.
This was just relayed to my subordinate.
Thank you. Thank you.
Thank you.
Incurred costs employing 2 advocates and a firm of attorneys to prepare the charge sheet and to act as a prosecutor and a chairperson of the disciplinary.
Yes, Commissioner, I will get to the cost factor because indeed costs were incurred, but not for the presiding officer. The presiding officer, as much as an instruction was issued, there is no work that the presiding officer has done. The people that would have done work is the prosecution team to prepare the charge sheet and the likes, and the consultations that they had with the potential witnesses of the municipality.
So all that money was wasted for nothing.
Effectively, this meant that the money becomes wasted. And there's going to be a discussion about that particular aspect. But I want to indicate that indeed the money became a wasted money because of the intervention.
Your policies and procedures, including the collective agreement, do they give the HOD of Human Resources the power or standing to give this kind of instruction?
No, not at all. Like I explained the delegations matrix before, the only person that was delegated in the municipality as of that time to institute disciplinary tribunals is the divisional head employee relations, no one else. The municipal manager would only institute a disciplinary tribunal in respect of a council resolution to discipline an HOD. And that is as per the disciplinary regulations for senior managers. The regulations stipulate that if council has taken a view that there must be disciplinary process, then the municipal manager, by way of council resolution, must appoint. But in respect of everybody else, especially people that are governed by the DPCA, the delegation resided with the divisional head employee relations and no one else.
Thank you.
Thank you, Commissioner. You make some remarks in paragraph 67 of your witness statement. Can I ask you to briefly share those with the Commission?
This Commissioners, is in line with my response that I've just given now to Commissioner Baloyi. And this is borne out by a process that the municipality went through, a very painstaking process that the municipality went through between, I think, started around 2016, that case, until around about 2022. This LAC judgment that I speak to here, where, again, unfortunately, it's in the EMPD. It seemed that this was a problem department, problem child department. It's in the EMPD when there was an attempt by the then acting HOD-HR. There was an acting HOD-HR in a recruitment process where there is a policy framework, and the policy framework provided that if you are going to do some form of exceptional circumstances recruitment, I'll say exceptional circumstances recruitment because there need to be a deviation from your recruitment and selection policy. That policy then gave the authority to have those exceptional circumstances processes to be done by the divisional head workplace, it was called workforce capacity management. And that divisional head had that authority, no one else. The policy is clear. Now, in this case, we had a situation wherein the acting HOD-HR intervened and processed an exceptional circumstances recruitment process. The matter went on. Unfortunately, it was just before the elections in 2016, and then a new, administration came in, but then Dr. Mashaz was the acting city manager. She became the acting city manager, and she did not approve the appointment of the person. We litigated that matter, went to arbitration. The arbitrator said, but if the municipal manager and the HOD-HR have taken a decision, the DH's authority stems from the city manager and the HOD-HR. Therefore, he surmised that it is proper. If these ones have taken the decision, they've effectively overruled the DH. We went on review. The Labour Court agreed with the commissioner that it was a reasonable award. We went to the LAC. The LAC said, no, it's not. The principle of legality vitiates that thinking because you have a policy position that says this person and no one else is delegated to do this function. So you can't have another functionary in the municipality taking over that function. So from that perspective, even though the HOD-HR was my supervisor, the function, the authority to do the function resided in the DH position. So the supervisor then does not have the authority to override the decision of the divisional head.
Did you show them the judgment, Mr. Ms.?
They have it. I mean,
I'm talking about at the time when they intervened in June 2023.
No, I didn't. Quite honestly,
because your point is that they had no power to do what they did, and you're relying on this judgment. So I'm saying, if that was your position at the time, why did you not say you don't have the power to intervene or to interfere? And here is a judgment that tells you that.
Yeah, Mr. Commissioner, sometimes you have to read the room. Honestly, you have to read the room. We're confronted here by things that were unheard of in my entire career in the municipality. Even the example that I gave earlier on about intervention by the municipal manager in 2017, it was not at this level. It was at the level where there was no disciplinary tribunal constituted. It was just a report from the department, and she stopped it even at that level and then instructed me to do a new directive on how these things must be handled. This one was just unique. This was unique. And the situation that we were faced with, quite honestly, we were not going to go up against Mashaza. Heads of departments.
I think people who abuse power are enabled by people below them who act defeated, and they just say, oh, well, I've read the room, you know, it looks like, I know this is unlawful, but I'm going to go along because what can I do?
In a way, you are correct. I believe also in that principle that in order for evil to prevail, it only takes good men to sit and do nothing. I believe in that principle. The system in the institution is such that if indeed you have that view, you have to then either submit a grievance to the mayor, and I can tell you now, grievances that are submitted to politicians honestly go nowhere. Alternatively, I think it's section 64. Again, section 64 talks about appeals, but they are mostly meant for your residents if they've got issues with regards to municipal decisions. Now, even if you were to do that, again, it goes back to submission to the mayor, you know, and the system, it's especially at municipal manager level. Yeah, I agree with you on the principle, but at municipal manager level, it's not that easy.
Is it a function, maybe I may ask, what is it a function of? Is it that there are no, that there isn't enough safeguards in the system that, and as a result, the kind of conduct that you're complaining about, including at city manager level, it has a fertile environment to function successfully? And what should be done? What is it that is missing in the system, in the governance system, in the regulatory system, that you would say permits this kind of behavior, if any?
Firstly, Madam Commissioner, I need to state that for me, honestly, this was a first. You know, I mean, this was in June 2023. I'd been a manager in HR in Ekurhuleni since August 2003. So in that 20 years, this had never happened. It has never happened. I've never seen such overreach by a municipal manager ever before. And as much as I've had to consult, brief, and indeed take guidance and direction from municipal managers over the years, and I'm talking about close to 6 municipal managers, inclusive of this municipal manager, she has never done this before, you know. And I don't know whether indeed she did it post this, or this was just an isolated incident, but you just get thrown, because indeed the system does not envisage that such would happen. You do not have anything in the system that provides you as I mean, we are, I can say divisional heads, part of, let's say, senior management with HODs and the municipal manager in top management, so be senior management. But you don't have anything that actually provides for this, because this is not, this was unique. This was unique, honestly. You know, besides submitting a grievance, which, yes, indeed, was open to me as an official, but beyond that, there is nothing really to do that could have been done.
So it's not,
the system doesn't, was not actually designed to anticipate this type of overreach.
Am I correct to understand you to be saying it's not so much a shortcoming of the system and the regulatory governance tools that are in place? It is more a personal, it's more a personal thing, the person and whatever informed their conduct. Am I correct
Yeah.
to summarize you that way?
That's on point.
Thank you.
Thank you, Commissioner. Mr. Ngiza, perhaps then to locate the totality of your evidence under this heading thus far, you've explained to the Commission that Brigadier Mkhwanazi was suspended in February of 2023, correct?
Yes.
And that suspension was uplifted after intervention from Ms. Xhasheka and the city manager. Is that correct?
I think it should be the other way around. After intervention by Mashazi.
There we go. The next event is upon the upliftment of the brigadier's suspension and his resumption of duty in May of 2023. Chief Mapieye made an attempt to move him out of his ordinary station. Is that correct?
Yes.
And that attempt to keep him out of his ordinary station in order to protect the integrity of the investigation was also blocked through intervention.
Yes.
The intervention of who?
Well, the letter came from Xhasheka, but I believe that it was per instruction by Mashazi.
Thank you. And you've now testified that in June of 2023, an attempt was made to serve the charge sheet upon the then Brigadier Mkhwanazi, and that the service of that charge sheet was blocked. Is that correct?
Yes.
And please remind the Commission at whose intervention that blockage was alleged to have occurred.
Mashazi and Xhasheka. Quite honestly, my sense is that it's Mashazi instruction to Xhasheka.
Thank you.
But at the center of it would have been Mashazi, and Xhasheka just follows because she's afraid of being shouted at.
Thank you, Mr. Ngiza. If I could then ask you to turn to paragraph 68 of your witness statement, please. 68, we're now on page 23.
Yes.
Yes. You've indicated the blockage of serving the charge sheet. Please then tell the Commission what steps you took immediately thereafter.
Well, I called Mapieye after I'd instructed Sidzamba to also record this blockage on email. I also called Mapieye, indicated that this is the situation, that the charge sheet has not been served. Well, he also just took note and said, it's fine, let's see what we can do.
Please continue with reference to paragraph 69.
And then on the next day, Chief Mapieye then called me. Remember, we had discussed the issue on the previous day. Then the next day he called me to say that he was called by Mashazi to her office and instructed to bring the docket. Then, when he got there, he was told that he must go and see Advocate Kemi Behari, who was the head of corporate legal services. And then when he had an engagement with Kemi, gave Kemi the docket, perused it, and then he took a view that there was no case against Mkhwanazi. I must also pause to note that indeed the docket did not have the charge sheet that was perused. The docket that was perused was the investigation report with its annexures, but it did not have the charge sheet from the lawyers at that time.
But the documents, the investigation report would have told him.
Yes, the merits.
Both the city manager, if she wanted to read it, but Advocate Behari, who is given the docket, the report would have told him what are the allegations.
Exactly.
Thank you.
So
it cannot be an answer to say Advocate Behari did not have the charge sheet, because if you want to know whether or not there's a case against Brigadier Mkhwanazi, you ask for the charge sheet. You can't say because it's not there, I'm going to form a view that there is no case.
Well, that is what is expected of a reasonable process. I'm not going to say a reasonable person. A reasonable process would dictate that indeed you must have the fullness of the situation in order for you to make an informed decision. You know, I honestly don't understand how this transpired, because you have a situation where the previous day a charge sheet is blocked from being served. So, for all intents and purposes, they knew that the charge sheet was there. There is a charge sheet. But for some reason, when there's an engagement with my PA, the engagement is limited to an investigation report, you know, and the concentration is to say that this investigation report does not have evidentiary material that to sustain the holding of a disciplinary tribunal. And I can tell you now, commissioners, this is discipline management. This is not a trial in court. You know, this is about discipline. You know, quite honestly, we have approved disciplinary cases on far less than what is contained in that bundle, you know, or in that docket, because this is about affording an opportunity to an employee to come and explain himself to the employer about his conduct or his alleged conduct, you know. So the test is not as strenuous. But nonetheless, you have a situation here where a decision is taken to say, no, there is no case here. There is no case here. And this version or this thing that is given to my PA gets given to me at a later stage as well.
Did Advocate Behari speak to you or to anyone from your section who have been involved with this matter when he considered the docket and he got to the conclusion that there is no case? Was there ever any engagement?
Not at this stage.
Not at this stage. And before this, had he been involved with you or anyone in your department relating to this matter?
Nope.
Before this point?
Before the 21st of June, there has never been a Kemi Behari, Advocate Kemi Behari, anywhere in the picture, especially on this matter. You know, when I had a conversation with Chief Mapia, you know, I was quite taken aback to say, but who can I guy? You know, where does he come in? You know, the delegations matrix at that point did not even involve him whatsoever. There was nothing that actually spoke to litigation. At this point, there is not even litigation. This is a disciplinary hearing. That's all. So there was no need for me to have a discussion with Advocate Behari. And for that matter, there was not even a need for me to have a discussion with Tlashega or Mashaz. There was simply no need.
And before this intervention, or now the involvement of Advocate Behari as, I think, head of legal, the legal person,
yes,
had the legal department gotten ever involved in disciplinary, other than litigating, when it's now at litigation, but at the stage at which the employee relations department is managing disciplinary processes internally? Is there a role for the legal department?
The legal department would get involved in discipline management matters at the senior management level. The disciplinary regulations, the heads of departments, they got involved. You know, I know that Advocate Kemi Behari was involved at some point when we were dealing with the COO. At some point we were dealing with an HOD. he got involved with those particular matters. You know, even then got involved because of his deployment by the city manager. But in the actual discipline management matrix, there was no need at that point for the legal department. There's a number of cases, even at HOD level, that had been processed. I mean, Advocate Behari was HOD corporate legal services from the 1st of March 2023. So historically, we would not have the involvement of the corporate legal services department unless there is a particular legal issue that requires their involvement, but only at that level.
And Brigadier Mkwana's position was not that senior management level you are speaking to?
No, it wasn't.
Thank you. Thank you, Ms. Mkwanazi.
Thank you, Commissioner. Mr. Ngliza, you say at the end of paragraph 69 of your statement, you say there that Chief Mapieye was subsequently instructed to withdraw the internal investigation into Brigadier Mkwanazi. In the following paragraph, you discuss the effect of that withdrawal. And please detail that to the Commission.
Yes, Commissioners, but the so-called withdrawal letter of the 22nd of June 2023, firstly, Mapieye was functus officio. His role ends at a particular point. You know, his authority ends at a particular point. And that point is reflected in his letter that I approved on the 12th of April 2023. Beyond that, he has no authority over the matter. You know, I am seized with the matter. So the letter of the 22nd of June was intended to undo something that had already, transpired. In essence, firstly, the letter says he's withdrawing an internal investigation. On the 22nd of June, there is no internal investigation. There is no internal investigation. The internal investigation was concluded in March 2023. It was brought to Xolani Ngqiza in April 2023. He had taken a decision on what then must happen going forward. There is no internal investigation. We have passed that stage. By the time the letter of the 22nd of June is issued, that letter for me had no force of law because it spoke to a process that does not exist anymore.
Is that not a form over substance argument? Because if the instruction was that the charge sheet should not be served and the investigation should be withdrawn, what is the substance of those two instructions taken together?
Okay. The instruction to not serve the charge sheet, especially at that point, was not in writing. And quite honestly, as much as I had spoken to my PA for an intervention, we always said this thing with Norman, you know what, this thing can be resolved at some point. But that for me, it's an instruction on a different process, even though the processes are linked in the sense that starts by investigation and then goes to disciplinary tribunal. But you can't say we are taking a view that the internal investigation be withdrawn when there is no internal investigation. I think that is the point that I'm trying to make. There was no internal investigation at that point.
In his evidence, and maybe in fairness to him, we should tell you what it is that he said, how he explains that. I don't have the transcript in front of me, but I think this can be summarized this way. His explanation is that he was being, subversive. He understood that the investigation is complete It was his way of trying to keep the disciplinary process alive instead of killing it completely. So he chose this wording deliberately, knowing that he couldn't withdraw a complete investigation, and yet there's no record that he's withdrawn the disciplinary action itself. I think that's a sum
Okay.
of his explanation.
Well, I understand it.
Thank you, Commissioner. Mr. Ngiza, in the following paragraph, paragraph 71, you set out in your own words what you say was the effect of stopping the charge sheet,
Yes.
viewed against the effect of withdrawing the internal investigation. Could you please set out your views there?
Yeah, my view is that indeed, like Commissioner Kumalo had raised it, that substantively it meant that the disciplinary proceeding could not proceed, because without the serving of the charge sheet, you can't have a hearing. So for as long as the charge sheet was not served, the disciplinary proceedings could not proceed at all, even though there was no official written withdrawal of the disciplinary proceedings per se, and technically it would mean the attorneys and the advocate were still on brief because there was no withdrawal of that particular instruction that they should prosecute the matter as it stood.
You are more asked the question because of your experience in the space as an employee relations person. Is it not a form of misconduct to intervene in this way without a rational basis for it?
It is. Straight up, it is.
And you would say, where does it belong in your code? Either in your code of discipline, which lists forms of misconduct, or as a matter of common law or law of general application? I ask because it bothers one that you would have this kind of conduct, which is highly suspect, if one, at best. It's highly suspect, and yet there's no consequence for it. And it has serious implications because it has someone who is accused of serious misconduct, very serious misconduct, who goes unpunished because those who have power by virtue of office, they use it to circumvent lawful processes. They're basically the law, collective agreement. It's a form of subordinate legislation, and they subvert the law for no rational basis. Surely it can be, that's the end of it, and there's no consequence for such people.
You are correct, Madam Commissioner. It can't be the end of it, and it shouldn't be the end of it. And perhaps critical in your analysis is the abuse of power by people that are in authority. This is a classical demonstration of such. You have people that are in authority, they step in and they cause something like this to happen. But not only did they cause something like this to happen, other things flowed from it. You have a person who was supposed to be disciplined and potentially be dismissed in June. In December, that person gets promoted. By who? By the very same people that stopped the discipline. The very same people that stopped the discipline. There's another issue that I'll be raising later on in terms of the effect of this stoppage. And you could see that indeed what was at play here is a serious And as by deviation would be
Mild way.
it's yeah, you know, to say that there was a deviation from processes and procedures would be, yeah, I know it's kindergarten language, and I can't find the right language to actually describe
Blatant
this.
disregard of the blah, blah, blah.
Blatant abuse of power in disregard of the law.
You know, if the evidence leader would allow me, if the evidence leader would allow me,
You
because-
have the chairperson's permission to speak freely.
freely, okay. You have a situation here to show, I just want to show how this thing actually played out. The disciplinary charge is stopped on the 20th of June. 2 weeks down the line, a report gets served that seeks to give Advocate Kemi Behari and Linda Tlashega a 600,000 rand increase. And that report does not provide any basis why such increases must be effected. These two people are appointed on the 1st of March 2023. They are still under probation. 4 months after their appointments, a report gets generated seeking to provide them with massive increases. And nothing has actually happened in the intervening period between March and July in terms of municipal processes. What is in that report speaks exactly to what they had in March, but in July, that is used to say these people must get these massive increases. I can only suggest or opine, but thank you. You are aligning yourselves to the instruction. You've aligned yourselves to the instruction. You've aligned yourselves to what I want as the city manager. My person is not to be touched, and you've ensured that my person is not touched. Here is an increase.
Unless, of course, there's evidence that on their appointment, the terms of their appointment was that at the end of the probation period, they would get increases. Yeah. I'm not saying that's what happened. I'm saying maybe it is some way.
There is no such. Doesn't exist in local government.
You are
because
the expert. I will not.
There is a regulatory framework that deals with what is called the upper limits for the total remuneration packages of municipal managers and managers directly accountable to municipal managers. That thing is determined by the Minister of COGTA. There is a framework on how such salaries are to be determined, how even cost of living adjustments are to be effected. But for the first time in the municipality, again, immediately after having protected Mkwanazi, increases were effected. So for me, it's yeah.
I'm going to test your opinion or your view again. You see, Parliament will say to people like you, we've done our job, we've passed the Protected Disclosures Act. Everything you've just said now, you could have made a protected disclosure and you would be protected from an occupational detriment. And the law is there for officials like you to use it. Why did you not use it?
I was suspended in September and dismissed the next year without even a hearing.
2 months later.
Yes.
But you accept that the law is there.
The law is there.
And
I've utilized the law.
at
I've
any
dealt with the
stage-
issues that pertain to that law.
between May and August, a protected disclosure could have been made.
I take the point.
Thank you.
Well, maybe let me add, and it's on the back of that you could have taken steps. on a quick look, the abuse of entrusted power is defined as corruption. So you could have gone to the police if with these things that don't make sense to you for the police to investigate. So there may have been an avenue that was not explored. Okay.
Well, there's things that I suffered, commissioners.
Yes.
There's things that I've suffered personally, even during the period that we are talking about. You know, there's things that I suffered.
Thank you. It's please do not understand us to trivialize the circumstances that you found yourself, not just you, in fact, even the witnesses that preceded you, to trivialize them and to be criticizing that you didn't do anything. It is simply to explore whether you realize or recognize that there may have been things that you could have done, but you didn't do because of the circumstances.
I think that we will perhaps, in the fullness of my testimony, then perhaps also revert back to an analysis of what could have been done, or, you know, what did I miss out, so that indeed if commissioners were to get a full sense of the circumstances that one was confronted with, then there will be a better appreciation of some lack or in terms of processes that one could have been able to put in place.
And remember, we have the benefit of hindsight, which is unfair to you, but take it in that spirit.
Thank you, sir.
Thank you, Commissioners. Mr. Ngiza, we are at paragraph 72. If I could take you back to paragraph 72 of your witness statement on page 23. In the last two remaining paragraphs of this subheading, you set out your frustrations following the inability to serve the charge sheet on Brigadier Mkhwanazi. You know, please set those out for the Commission in summary of this topic.
Thank you, Council. Of course, the legal team or the prosecution team that was appointed were very frustrated. They raised issues to say, but how can this be left unattended? I mean, remember, they had consulted with witnesses. They had even a much more fuller appreciation of what was at stake, because they not only had the documents, but they had a human view, you know, a human touch on the issues. So I engaged with the advocate that was appointed, and of course, he indicated his frustrations. I also indicated my own frustrations back to him, because the matter was scheduled to sit on the 3rd of July, in line with the 3 months that one was chasing, that within the 3 months the matter must commence. So there was that particular frustration that was expressed by all involved, let alone the frustration in the department in terms of senior management of the department. At a later date, I was updated that not only did the charge sheet not go out, but the external lawyers were also not paid. You know, of course, this was frustrating, and indeed, we were incapable to proceed with the disciplinary hearing at all.
And can I ask you to read that last sentence of paragraph 73 into the record?
Despite engaging the most senior official at EMPD, which would be the Chief of Police, my superior, which would be the HOD-HR, and the city manager, brought any inquiry into Brigadier Mkhwanazi to a halt.
Thank you. And Mr. Ngiza, Do you know if these charges against Brigadier Mkhwanazi were at any point ever served on him, or an attempt was made to revive or resuscitate this process? I ask the question mindful of the fact that you left in March 2024. At that point of departure, were you ever aware of an attempt to revive or to attempt to reserve the charges on the Brigadier?
I need to correct the point about when did I leave. I was suspended effectively on the 7th of September, 2023, and I was rendered a persona non grata. You know, there was a directive issued that not even a single person was to speak to me from the municipality, let alone from my division. I was even actually, I even raised an issue to say, I was told that I must not even go to municipal offices even to pay for my rates and taxes. So that ordeal didn't just happen in March 2024. But coming back to your question, nothing has ever happened to Brigadier Mkhwanazi. Nothing.
That you were aware of, up to and including your point of termination?
Nothing.
Thank you.
Instead of something happening, he got promoted. Something happened. I'm wrong. Something did happen to Brigadier Mkhwanazi. He became a deputy commissioner.
Do you think your suspension had anything to do with the charges, the suspension of Mkhwanazi, the charge sheet, and all of those, or it was unrelated?
Can I hold on a bit? Let's go into the next. I need to get the fullness of what happened, Commissioner. I need to get the fullness of what happened and how these things actually unfolded.
Okay, you can stop me as well if it belongs in what you're going to be saying later, but I'm asking the question on the back of what the last thing you said, which is instead he got promoted. Now, we've had evidence, I think from Chief Mapie, about an interview, a selection process, application, shortlisting, and something else that ended up prematurely without that ended prematurely because a step that was supposed to complete that process was not done, but the next thing he was appointed and he got his colors. Do you know anything of, I struggle to remember the name of that thing.
His rank.
His rank. But didn't learn to wear it properly. Were you involved with that selection process? Do you know anything about it?
Madam Commissioner, I was not involved with the selection process, but I do know about it. And again, this is another demonstration of how disregard, to use the chairperson's language, disregard for policies and procedures has been a norm of late in the municipality. Firstly, and this is from my understanding in terms of even my engagements, even post my suspension, because even though there was this directive, I do get engaged by people on a number of things. The selection panel that was used, I would criticize it. This was a position of a divisional head level, very senior, in the police environment, which is a very specialized environment, specialized in its functionality, specialized in its regulation. Then you have a selection panel where it is the chief of police, of course, who's an expert in policing. It is the HOD HR, who knows nothing about policing, with all due respect to herself. It is the HOD, Sports, Recreation, Arts and Culture. Nothing about policing. Now, the problem with how recruitment and selection happens in our environment, and this is a criticism that I even actually made in a matter where we were a respondent in an unfair labor practice dispute relating to promotion. And the criticism that I made, and fortunately for the municipality, we won using that criticism, is that you have a situation where the actual suitability of a candidate for appointment is premised on an aggregation of the scores. You aggregate the scores of the three panelists. And then, having aggregated the scores of the three panelists, the candidate that has got the highest score gets to be the one that is recommended. Now, in a situation like this one, the two people that are not experts on policing, I have not seen the scores, but I can tell you now, would have scored Mkhwanazi better than the person who's an expert on policing. Because there's a predetermined notion that he will be promoted, come hell or high water. That is the first point of call, before even getting to the other steps, how this thing was structured. It had a predetermined outcome. So whatever the chief of police scores do not be used as a benchmark of how the person is answered. If the chief of police scores the candidate 2 and the other panelists score the candidate 4, aggregate the scores, that candidate becomes the highest scored person, even though the expert said these answers are not correct.
Is that a fair criticism, though? What options were there within the municipality to constitute the panel differently, taking into account what you're saying about experience, that the people who know anything about the environment should not have been there? I think that's a nub of what you're saying, that you've got two people who know nothing about policing. What would have been the options available to the person constituting that panel, apart from the chief, who is an obvious choice? What options would there have been for the other two?
The options that would be for the other two are informed by what has happened with previous appointments at that level in the EMPD. All right? Because this was not the first time that the EMPD was having an appointment of a deputy chief of police. It was not the first time. So in previous instances, you would have the chief of police and the head of department disaster and emergency management services. The head of department disaster and emergency management services is the closest, because that person is involved in the uniformed service. In the uniformed service, and indeed there are those overlapping functions that actually are involving both EMPD and DEMS. We call them DEMS, Disaster and Emergency Management Services. So the precedent in the municipality has always been that DEMS HOD, even if it's an acting HOD of DEMS, would sit with the chief of police.
All right.
That has been the precedent.
Okay.
But I can tell you now, there's been a number of instances where, when we are having a divisional head position, specific individuals are then drawn to be the panel, because a particular outcome will then be determined. Specific individuals that are consistent in the panels for divisional head positions.
I interrupted you. You were still explaining what you know about that process that ended prematurely, the selection process, but somehow
Yes.
Brigadier Mkhwanazi was selected.
Thank you,
Please.
Madam Commissioner.
Please hold that thought. Let me continue the interruption. On the facts that you are aware of, why do you think the city manager was as invested as she was in Brigadier Mkhwanazi? I wanted to also include Ms. Tasheka, but I'm not sure whether I should, because at some stage you said that she didn't want to be shouted at and wanted to see the finalization of the DC process without a hearing having taken place. So maybe let me leave her out of the equation for a moment. So why do you think, on the facts that you know, the city manager was as invested as she was in Brigadier Mkhwanazi?
Thank you, Chair. I think, Chair, there's a point, I think it was I'm not sure it was yesterday or early this morning, when I had to give a view on the proximity claim. And I indicated that when you look at the hierarchical arrangement of the municipality, there shouldn't be a proximity between the two individuals. But nonetheless, that proximity does exist, And perhaps one would have to then investigate what informs this proximity. Because this proximity, in my view, is what then informs the municipal manager's attitude, the municipal manager's conduct when this individual is involved. When this specific individual is involved. There's a number of matters that we've dealt with this municipal manager. A number of matters, including HODs, including other people that were even in her office, directly in her office. But this was unprecedented. And the only thing that one can opine is that it is unprecedented, and it is the type of conduct is informed by things that are extra. Is there extra organizational? There's extramural activities, So there's something that is beyond organizational arrangements that, in my view, exist between Mashazi and Mkhwanazi. That would then inform the proximity claim. That would then inform the conduct of the municipal manager in respect of this individual, protecting the individual, not only protecting the individual, advancing the individual. There's so many things. You have a situation where, and it's just unheard of in the municipal environment. A person gets appointed to a position that is the equivalent of other positions, and there are other people that are occupying those positions. This one comes now, umafikizolo, literally this is the mafikizolo. But then the mafikizolo gets to act and be the supervisor of the people that have got more service, more experience, more qualifications, more this, more that. But this person gets to act. And these ones never get to act at all. For as long as Chief Mapie was on leave, was put on special leave, was suspended, one person acted. Council policy on acting is clear. There must be a rotation of acting. But there's no rotation of acting. This person gets favored above everybody else. And there is no rational basis in terms of the institution, in terms of processes of the institution that I can think of that would put the municipal manager in that position where she has to make sure that this one person enjoys protection, enjoys benefits, enjoys everything. There is nothing institutionally. So then it has to be on a personal level. The allegation against me and Chief Mapie is that we are personal against Julius. I don't know how do I become personal, Chair. I don't even know the man. I've never seen him outside of uniform. I've never seen him outside of uniform. I've never even met him at a funeral, except for a funeral of an EMPD official, where even then he's in uniform. But I'm personal against him. I don't even know where he stays. I don't even know his family. I know nothing about him, except for the fact that he's an employee of the municipality. You know.
Based
But
on
here, clearly, there is some personal relationship.
Based on what you know, would you say that Ms. Xasheka's claim that she did not want to be subjected to continued rebuke was the full answer to how she herself conducted herself with regard to Brigadier Mkhwanazi?
My understanding of Ms. Xasheka and her tenure as the head of department HR, which would have commenced when her predecessor left the institution, I think it was at the end of July 2022, and then Ms. Xasheka was appointed to act in the position from August 2022 until the 28th of February. She was acting, and then she got appointed from the 1st of March. There is no other rational basis that I can think of that would make her, as an HOD-HR, you know, to act in the manner in which she acted, except for her fear of marshals. Because that is how she has always addressed herself.
That's exactly what I want you to address. On the basis of what you know, do you think that the manner in which she acted was indeed motivated by her fear for Ms. Mashazi?
Nothing else.
Thank you.
Thank you, Chair. It's 4:01.
Let us adjourn and resume at 9:30 tomorrow.
Emapili monna ba tlose dilo tsaka.